Bienvenidos al Instituto de Investigaciones Jurídicas. Usted se encuentra en el auditorio Dr. Héctor Fix Zamudio. Por su seguridad, estas son las medidas preventivas que deberá adoptar durante su estancia, así como las acciones a realizar en caso de presentarse una contingencia. El recinto cuenta con sistema de alertamiento sísmico, sistema contra incendio como extintores, detectores de humo e hidrantes, así como botiquín de primeros auxilios. Se cuenta con 2 salidas de emergencia, el acceso principal es una y en la zona inferior del lado derecho se encuentra la otra. Identifique la ruta de evacuación, zonas de menor riesgo y punto de reunión. Mantenga despejados los pasillos, escaleras y salidas de emergencia del recinto. En caso de activarse la alerta sísmica, conserve la calma, permanezca en su lugar y siga las instrucciones del personal. En caso de incendio, mantenga la calma y evacúe el recinto siguiendo las instrucciones. Si requiere atención especial, indíquelo al personal del staff del evento. En caso de evacuación, diríjase al punto de reunión de manera ordenada y en silencio siguiendo la ruta de evacuación señalizada. Gracias.
Adelante. ¿Empiezo? Directo. Buenos días a todas y todos. Permítanme, en nombre de la doctora Mónica González Contró, directora del Instituto de Investigaciones Jurídicas, darle la más cordial bienvenida al instituto, a las personas que nos acompañan de manera presencial y, por supuesto, a las personas que nos acompañan por la plataforma Zoom, que sé que son varios los que están y las que están ya conectadas. Quiero saludar a María José y a Hugo, personas que me acompañan el día de hoy en el Presidium, y también saludar, agradecer y felicitar a Carlos Reyes y a Ricardo Ramírez por la coordinación y la organización de este evento. Como todos los presentes seguramente saben, World Arbitration Update tiene como uno de sus objetivos poner al día a la comunidad mundial sobre temas clave y novedosos acerca del arbitraje comercial internacional y de inversiones, así como del derecho internacional público en un foro que se ha pensado e implementado desde la descentralización institucional, pero sobre todo desde la descentralización geográfica. Este tipo de eventos, y esta conferencia en particular, promueve y alienta el debate abierto entre profesionales, estados, actores privados, árbitros, organizaciones internacionales, académicos y estudiantes, buscando conectar a las diferentes regiones del mundo con el objetivo de buscar alternativas, crear estrategias y pensar en la mejor manera de ampliar el arbitraje y el derecho internacional público. Esta nueva edición de World Arbitration Update México 2025, que por segunda ocasión se celebra aquí en el Instituto de Investigaciones Jurídicas, es un gran logro. El Instituto es un espacio dedicado desde hace décadas al estudio riguroso del derecho y a la reflexión crítica sobre los desafíos que enfrentan nuestras instituciones jurídicas. Hoy nos convoca una agenda global urgente. Los retos que enfrenta el Estado de Derecho en el comercio y en la inversión internacional, en un momento donde las tensiones geopolíticas, las reformas legales de corte autoritario y el debilitamiento de los mecanismos institucionales están poniendo a prueba los principios fundamentales que sostienen el orden multilateral. A lo largo del día se abordarán temas clave como el arbitraje internacional de inversiones, la transición energética, la reforma judicial mexicana, el impacto de los cambios políticos en América y el futuro del sistema de solución de controversias entre estados, en contextos donde la legalidad muchas veces cede terreno ante el poder político. Además, en un mundo globalizado, las políticas de un país tienen efecto en otros países, en especial en materia de comercio, de bienes y de inversión. Agradezco la presencia de panelistas nacionales e internacionales, expertos y expertas que compartirán con nosotros no solo diagnósticos, sino también propuestas para fortalecer las instituciones jurídicas en un mundo cada vez más fragmentado. Seguro de que será un espacio de mucha reflexión, pero sobre todo que discutirán para buscar alternativas y posibles soluciones a los desafíos que enfrentamos en el mundo de hoy. Les deseo mucho éxito en el trabajo. Muchas gracias y bienvenidas y bienvenidos.
Bueno, buenos días a todos. Mi nombre es María José, yo soy asociada en Strategy y solamente para complementar lo que Mauricio nos estaba diciendo, quiero agradecerles a todos en nombre del equipo del WOW, de las organizaciones que nos apoyan y especiales e infinitas gracias al doctor Carlos, a Hugo, a la UNAM, al Instituto de Investigaciones Jurídicas por todo el apoyo y por ser grandes hosts. Definitivamente creemos y no tenemos duda que va a ser una sesión infinitamente gratificante para todos, gracias a los que están aquí presenciales y a los que nos acompañan virtualmente. El WOW fue creado para exactamente esto, crear espacios de debate, de desarrollo, hacer update de lo que pasa en nuestras regiones, porque obviamente tenemos países de todos lados del mundo, entonces nada, muy felices de estar aquí y esperamos que a todos les encante, tanto como a nosotros disfrutamos hacer este evento.
On behalf of RRH Consultores, we want to thank the Instituto de Investigaciones Jurídicas, Strategy, and all those coming from abroad. Thank you. Thank you also to the audience that is watching either or seeing us here in person or watching this video today or at a later stage. The World Arbitration Update is taking place here in Mexico City, but during these days, it's also taking place in Singapore, The Hague, Bogota, and other cities. Thank you finally to the sponsors. Those, for example, Suru, Akike, Rangel Perez for supporting this event. And finally, but more importantly, I think, is you, the audience. So, well, I have nothing more to add. And thank you, Mauricio.
Gracias.
So the next panel will start in 2 minutes.
Ready.
Do you? Okay. Well, good morning, everyone. Thank you for joining us for this panel on global trends, the energy transition, and infrastructure in investment and commercial arbitration. We are privileged to have with us both leading academics and practitioners who have shaped the negotiation and interpretation of investment treaties and commercial contracts in the energy sector. Let's start with the numbers. According to the 2020 Queen Mary University of London Energy Arbitration Survey, energy disputes are among the most prominent in international arbitration. In fact, energy-related cases consistently account for a significant number caseload major in arbitration institutions. For example, ICSID's 2023 caseload statistics show that approximately 20% of all new cases registered were related to either oil, gas, and mining, with a growing proportion involving renewable energy and infrastructure projects. The Queen Mary survey further highlights that 40% of respondents prefer arbitration as the dispute resolution method for energy infrastructure disputes, and 72% rate arbitration as highly suitable for the sector. What is driving energy disputes in arbitration recently? The energy sector is undergoing a profound transformation, and it is reflected in the disputes we see. The Queen Mary survey and recent ICSID reports identify several key trends. First, regulatory change and energy transition. 60% of survey respondents expect regulatory changes such as climate policies, subsidiary reforms, and treaty implementation to be the leading cause for future disputes. The shift to renewables, the phasing out of fossil fuels, and the introduction of carbon pricing are all creating legal risk and uncertainties. Secondly, price volatility and supply chain disruption. The volatility of energy prices and the impact of geopolitical events have led to a surge in disputes over contract performance, force majeure, and hardship claims. Thirdly, another sector is infrastructure and technology. As the sector invests in new infrastructure and technologies, disputes are arising over construction, procurement, and contract performance. Lastly, is security of supply and sanctions. The need of energy security and the imposition of international sanctions have triggered disputes over project suspensions, terminations, and the reactivation of previously abandoned fossil fuel assets. Energy conflicts are not new. Actually, we can relate to landmark cases and identify which can be the lessons from that practice. For example, in Europe, Spain and Italy have faced dozens of claims under the Energy Charter Treaty after retroactively withdrawing renewable energy subsidies. Some cases, as ISER versus Spain or Masdar versus Spain, tribunals found that abrupt regulatory changes violated investors' legitimate expectations, resulting in substantial awards against the state. In North America, the case Lane Pine versus Canada under NAFTA addressed the balance between environmental regulation and investor rights, as Quebec's fracking moratorium was challenged as an expropriation. Now, as we can see, arbitration and energy are very related, but which are the challenges and opportunities for this area? Arbitration remains the preferred forum for resolving these complex cross-border disputes. Its neutrality, enforceability, and the technical expertise of arbitrators are highly valued. However, the sector is calling for innovation, expedite procedures, greater efficiency, and more tailored approaches to the unique challenges the energy and infrastructure cases require. At the same time, the legitimacy of investor-state arbitration is under scrutiny, with ongoing reforms debates at the UNCITRAL. There is a growing emphasis on balancing investor protection with state right to regulate in the public interest, particularly in the context of energy transition and climate change. In this panel, We will explore these issues through a series of questions to reflect both the academic and practical dimensions of the field. We will examine how recent shifts in the US and Mexican policy, as well as the evolution of NAFTA to USMCA, are reshaping the landscape for energy and infrastructure investment. We will also discuss the impact of regulatory changes and the review of the USMCA on dispute resolution procedures in North America. Finally, we will address the challenges faced by the arbitral tribunals in balancing investors' protection, public interest, and the demands of energy transition, drawing on both recent jurisprudence and experience of those who have negotiated the investment treaties. In sum, the intersection of global energy transition, infrastructure investment, and international arbitration is one of the most dynamic and consequential areas of law and policy today. I'm really looking forward for this panel so we can have the point of view of both scholarly insight and hands-on experience practitioners who are referring to these questions. Now we are ready to start with our panel, and I am very pleased to introduce our outstanding panelists for today. We have Carlos Reyes Díaz, who is a tenured professor at Instituto de Investigaciones Jurídicas de la UNAM, in the fields of international trade and investment arbitration. He has an experience of 23 years, and he also acts as independent arbitrator under the rules of the International Chamber of Commerce and the London Court for International Arbitration. Secondly, we have Lauren Mandell, who is a partner at the law firm WilmerHale in Washington, D.C. His practice covers both international trade and international arbitration. Prior to joining WilmerHale, Lauren was a lawyer and negotiator at the Office of the U.S. Trade Representative under the Obama and Trump administrations. In that capacity, Mr. Mandell was the U.S. government's lead negotiator on investment in the U.S.-Canada-Mexico agreement. He also led aspects on the Section 301 investigation of China trade practices that culminated in the U.S.-China Phase 1 trade agreement. Outside of WilmerHale, Lauren is an adjunct professor at Columbia Law School, where he teaches a class on U.S. trade and investment policy. And our third panelist is Orlando Perez. He is an expert lawyer in investment arbitration, commercial disputes, and international trade with experience in the government sector. He participated as part of Mexico's negotiation team for the USMCA. Currently, he serves as partner at Suro Aquique Rangel Perez, a law firm focused on technology, trade, and intellectual property. Additionally, he is a professor at the Faculty of Law of UNAM. As you can see, we have a really outstanding panel with colleagues who have been participating actively in negotiating the investment treaties in North America, and the idea is for us to address the most important topics that are related to this area, and we will ask some questions to our panelists and have a really enrichful discussion. So first, we would like to start with a question to Orlando. Orlando, regarding your experience, how does the USMCA and bilateral investment agreements signed by Mexico or the United States protect foreign investors against regulatory changes related to energy transition policies?
Thank you, Sylvia. And first of all, I want to thank the World Arbitration Update for inviting me, and also the people from the Instituto de Investigaciones Jurídicas and my good friends from RRH Consultores for organizing this event and to take me in consideration to participate in this event. I am very honored and very glad to participate with my colleagues here in the table with the coordination of Sylvia and my good friend Carlos Reyes for many long years, and also Lauren for many battles in the past, and to see also familiar faces here in the room. So I was, obviously we worked together to organize these questions, but when I put the questions or my questions, I didn't know the answers. So I was thinking yesterday how to approach this question, basically from the perspective of this issue of energy transition and infrastructure, and what are the tools that foreign investors has in case that they want to initiate a case against Mexico or the US or any country in the North American region, on the basis of some changes in the energy sector or transition, or a new policy of the, in the energy sector or infrastructure. And I found that there could be two ways to analyze this. One is these policies that has changed from, I will say, the old type of energy and to phasing out this type of energy to have this energy to new type of energy, like renewable energy. Or the other type of policies that we have been seeing in the region is to do the opposite, no? That countries that doesn't want to maintain this, I will say, regulatory schemes for fostering renewable energy, and they want to come back or make a backlash to the new set of rules and to return to the old school. So it depends on which aspect you have or a specific case that you are facing. But based on what the USMCA provides and the bilateral investment provides in terms to foreign investors, everybody knows here in the table that the main issue is that Chapter 14 of the USMCA provides an investment provision that sets some principles or some obligations, and also provides a mechanism to dispute settlement with a lot of changes vis-a-vis the Chapter 11 of the NAFTA. But at the same time, the bilateral investment treaties that Mexico has signed or other countries like the US has signed or Canada has signed has also some provisions to protect investors and provide a mechanism to settle disputes. Some of these provisions you already know because many that are here are more expert than myself, but provide key protections like non-discrimination clauses. Basically, the BITs prevent host countries from unfairly discriminating against foreign investors, offering them treatment comparable to domestic investors or those from other nations. We also know that many of these instruments provide provisions of minimal standard of treatment. This provision has been long-standing in many agreements, including the Chapter 11 of the NAFTA, and has been in some way also incorporated in the Chapter 14 of the USMCA with some caveats. And this provision provides a rule based on the customary international law and a floor provision to provide a treatment to, from the states to foreign investors, basically with two sets of principles. One is fair and equitable treatment, and the other is full protection and security. Also, we have provisions in the BITs and also that provision that has been incorporated in the Chapter 14 to protect, BITs and Chapter 14 or the investment chapters in the FTA does not prohibit expropriation, but regulates in the way to any state wants to or perform an expropriation. But basically protect the investors to not face an expropriation directly or indirectly unless some conditions are met. We also have provisions with respect to provide access to a mechanism to international arbitration. Obviously, every single chapter has some differences. What we have seen in the past in terms of energy transition or this type of measure is that the USMCA provides some specific changes that we will elaborate further, but these changes has basically reflect the way that the chapter now is constructed in several annexes, when you have basically two specific mechanisms to dispute settlement. One is what they call the skinny ISDS, and the other is what is called like the full ISDS. So for energy transitions, for infrastructure, investors from the US, only from the US and in Mexico, or Mexican investors in the US have access to a full system to settle their disputes, including the possibility to argue claims of minimal standard of treatment or indirect expropriation. But there are some differences between these two types, and we will continue, I guess, digesting or discussing about this issue.
Thank you, Orlando. Definitely what you share with us about these changes in the regulation of investment arbitration, how it's been addressed differently in all the BITs, is definitely something that should be taken into consideration, because each treaty is different and it has to be treated in the specific situation it is expected. So regarding what you just referred with us on these changes about the USMCA, I want to invite Lauren to share with us your opinion about how do recent shifts in the U.S. policy affect the resolution of investment disputes in Mexico related to energy and infrastructure.
Thank you very much, Sylvia. And let me add the thanks that Orlando.
I think your mic is.
Oh, is this better? Oh, thank you. That was the most important part that you missed, the thank you. Thank you for having me here in Mexico City. Thank you to the Institute, to Carlos, to Sylvia, the moderator, to RRH, many friends, old friends and new friends. Very grateful to be here. The question of U.S. policy changes over recent years and how they relate to the resolution of investment disputes is one that I've spent a lot of time on in government and outside of government. I think the overall big picture is that over the last 8 years, both Republican and Democratic administrations in the United States have made decisions that are not conducive to the resolution of energy disputes in North America. There's been a movement away from investment arbitration in U.S. policy, and there's not been a new vision, I think, of if not using investor state, what should the tools be to resolve disputes in the energy sector and also other sectors. Very quickly, I want to look at the last 8 years in maybe less than 4 minutes. You have, in 2017, President Trump's decision to withdraw from the TPP, the Trans-Pacific Partnership. Now, many will know, many NAFTA scholars in the room will know that one of the significant features of the TPP, as between the United States and Mexico, was to address some lack of clarity, some ambiguity in the NAFTA with respect to the resolution of investment disputes. I would go as far to say that in 2017, the United States and Mexico did not agree on how NAFTA should be interpreted in light of the 2014 energy reforms in Mexico, how those reforms relate to Mexico's non-conforming measures in the NAFTA, various other annexes. And you know, the agreement, TPP, was a chance to confirm effectively that U.S. investors, Canadian investors in the energy sector had the right to use investment arbitration to vindicate their rights in the energy sector. That was a missed opportunity in some respects when Trump withdrew on day one. Then you look forward to the rest of the Trump 1.0 administration, and you have the renegotiation of the NAFTA, the TMAC agreement. As Orlando begun to explain, you know, TMAC limited access to investment arbitration for investors in all sectors. Energy investors may be a little bit better situated than other investors, but still major hurdles and obstacles to access arbitration to resolve energy disputes. And you know, I can say from my experience in the negotiations, that was a U.S. proposal. That was something the United States affirmatively wanted to do, was to restrict access to investment arbitration in all sectors, including in the energy sector. And then you look at the Biden administration over 4 years, very critical of investment arbitration from the very beginning, from you know, the early statements from the president and from the USTR, the State Department. Here you also have an interesting bit of history that for the first time in modern US history, the Biden administration initiated a state-to-state a U.S.-Mexico dispute with respect to energy. Many in the room will remember this in July of 2022 regarding the electricity law in Mexico and also regarding permitting decisions around oil and gas. They initiated a consultation process, but they never initiated, the U.S. never initiated a panel process. And so the case was unresolved. And I think that was really kind of emblematic of an administration that wasn't particularly comfortable with using whether arbitration through investment arbitration or through state to state on investment issues, on energy issues. And then finally, and we'll talk more about this in the next hour on Trump 2.0, yesterday, or 2 days ago, excuse me, was the 4-month anniversary of the second Trump administration. For many observers, it feels like many more months than that. There has been, as many know, a very clear focus on investment in the United States, not so much investment in Mexico, in Canada, in other jurisdictions. On the other hand, and the picture I think is somewhat muddled here, we're still at the very beginning of the administration, you do have the administration showing interest in confronting unfair trade and investment practices in other jurisdictions. And an example that I would use is on digital trade. You see the Trump administration talking very vocally about digital services taxes that some governments have promulgated to tax the revenue streams of big U.S. digital platforms like Amazon, Google, et cetera. And that I think is somewhat of a break from the Biden administration, which again was not just critical of arbitration, but also reluctant, I think, to advocate on behalf of U.S. companies abroad. And you also have, I think, a different tone on investment arbitration. If you look back at the hearings when the USTR, Catherine Tai, under the Biden administration, was asked about the USMCA, about investment arbitration, about energy, she had very negative signaling from the very beginning in 2021, suggesting that the administration would not support arbitration. When you look at the confirmation hearings of Jameson Greer, the new USTR trade representative, he was asked by multiple senators about his views on resolving investment disputes. And he said, we will work with Congress to resolve the issue in the USMCA negotiations and others. So I think there's a window that they've left open, they meaning the Trump 2.0 administration, to have a sort of revisiting of how do we resolve investment disputes in North America, including in the energy sector. Is investment arbitration a la NAFTA the best approach? Is there a different approach using investment arbitration that might be something they would pursue? And again, we'll talk about this, I think, a bit more in the next hour.
Thank you, Lauren. Well, thank you for sharing your point of view and experience from the U.S. side. And now we invite Orlando to share with us what were we living in the Mexican side as all these negotiations and through all these years that Lauren shared with us was expecting the Mexican government.
Yes, for sure. I think that, sorry, to return the points of what Lauren has mentioned, I will start basically and with a recollection. Obviously, he mentioned about the changes in the energy sector and the initiation of consultations in Mexico. But at the same time, and I think that everybody here knows the same information, has the same information that is in the media. The U.S. took the decision to not move ahead that consultation. I could not speak about what happened there because I was in the first stage, but I was not in the later stage. And I know what everybody knows here in the room. So last October, the new administration introduced a reform, a constitutional reform on energy. This reform helps the administration to introduce several, I would say, secondary laws that has been approved in February. This laws was published in March. And now the system has completely changed from the Constitution through the legislation. What are the tools that investors may have, or what are the tools that the US or Canada have with respect to these measures is that they need to push Mexico to explain why these new reforms are consistent with the USMCA, either perhaps through the Chapter 31 of the state-to-state dispute settlement mechanism, or through policy, or to bilateral discussions, or through in the review of the USMCA. Obviously, the changes, or these changes in the constitutional reform has changed dramatically the power that the state has provided to the state-owned enterprises and the privilege to those companies in terms of the energy, and they have in some way removed a little bit from the 2014 energy reform. And we need to see what will happen. I don't know with respect to investment arbitration, because I think it will depend whether the investor has some contracts, and these contracts has, for this reform, has reduced the opportunity to perform these contracts, so they will have a tool to use, I will say, the full ISDS or a BIT if the conditions in those cases appear that the investor is facing some problems. My impression is that many companies has tried to adjust of the new rules. The new rules imply that is 54% of the electricity is, the government will provide some preference to the state-owned enterprises, and 48%, I can't remember, but it's something like that. It's 54 from the state-owned enterprises and 46 for the private sector. So the private sector has some room, but this room is completely different of the measures that we have in place in 2014. So there is a big question mark on whether the foreign governments will accept these new provisions from Mexico, or the investors will take advantage and try to pursue a case. No?
Well, that's something important to take into consideration, because we were just talking about the change from NAFTA to USMCA, and as Orlando just referred, the situation was different. So, Lauren, now that you have shared with us all the experience you have in negotiating the change from NAFTA to USMCA, and considering the current situation of this energy sector in Mexico, can you just share with us which were the changes made to investment arbitration mechanisms from NAFTA to USMCA, and refer if they still provide the same level of protection they used to have before the change to USMCA?
Of course. The changes between NAFTA and USMCA with respect to investment are amongst the most substantial changes between the NAFTA and the USMCA of any subject matter, in my view. In NAFTA, you had an approach that was somewhat novel at the time of having every investor in any sector having the right, a U.S. investor in Mexico, a Mexican investor in the United States, of course Canada as well, to bring claims for violation of any of the rules in the investment chapter, effectively around fair and equitable treatment, discrimination, expropriation, et cetera. And you had a tremendous amount of arbitration going in all different directions. The United States, I think, was quite surprised that it became the target of many investment claims during the NAFTA region, or NAFTA period of time. That was NAFTA. In USMCA, and I can speak from my own experience here, in 2017, Ambassador Robert Lighthizer, the USTR at the time, wanted to do things differently. He viewed investor state as problematic from two different vantage points. One was defensive in nature. There was a kind of principled objection that the United States laws, regulations, judicial decisions should not be subject to review by an international tribunal of any kind, this sort of sovereignty argument. And then on the offensive side, Robert Lighthizer and President Trump as well, I think were concerned that the NAFTA-style access, the broad access to investor state, had incentivized, in their view, U.S. companies to move their production, to move jobs from the United States to Mexico. And so from the very beginning in 2017, in May of 2017, when Robert Lighthizer was confirmed as USTR, he wanted to do things differently. And fast forward, where we ended up was an approach that Orlando had begun to explain of two tiers of investors. One tier, most investors in most sectors have access to, skinny, I think that term is the term we used at the time, very, very skinny ISDS, meaning only access to investor state if you have a claim related to direct expropriation, not indirect, or if you have a claim for violation of national treatment on a post-establishment basis. And also, in order to bring a claim, and this was, I think, very critical as a sort of barrier, a US investor or a Mexican investor would have to litigate their claim in the domestic courts of the other country for up to 2.5 years before they could access investor state. And I should mention, this is between the US and Mexico. Canada was not party to the investment arbitration procedures in the agreement. And so very substantial changes. One thing I'll mention, or maybe two quick points. Now that we've seen the performance of the USMCA for 5 years now, I can say that I think that US investors do not view the USMCA as providing a particularly meaningful path to resolve disputes related to investment, either under 14D, the skinny ISDS, or under 14E. Under 14D, I'm not aware of any successful claims of any kind. Under 14E, and I should have explained some more of the detail, if you're not in the skinny category, if you have a certain kind of contract with the federal government, the national government, in one of several covered sectors, including oil and gas, transportation, telecom, infrastructure, then you may have access to the sort of traditional full scope ISDS, no requirement to litigate in the domestic courts. But I don't believe that any tribunals now, 5 years in, have even accepted jurisdiction over any such claims. I'm not personally aware of companies that are considering using Annex 14E. It is a key to access, broader access to investor state, but I'm not sure how meaningful it is. The other thing I'll mention, though, and this is going back to the skinny ISDS for a second, that requirement to litigate in the domestic courts of the other country, I think, takes on a kind of different meaning in light of the judicial reforms here in Mexico. I think there are many US investors that, even before these judicial reforms, would have been skeptical of having to litigate a claim for 2.5 years in domestic courts before using investor state. But I think particularly with the judicial reforms, there are companies that I've spoken to that view it as a non-starter, that we can't consider putting stake in a process that would require us to litigate in courts where the independence of those courts is in question. I'll pause there.
Well, you definitely lead us with a hot topic for all of us, addressing the election of the judicial system here in Mexico. And now I want to invite Carlos and ask him, take into consideration all these situations in which maybe the courts may not be the ideal forum, and then the energy sector referred to arbitration. This challenge the arbitral tribunals realists have in order to resist authoritarian drift, especially when facing states that reject international rulings or manipulate the regulatory process. How do an arbitrator can address this matter?
Thank you so much, Silvia. Well, I'd like to start by thanking all the people involved in the organization of this event, especially RH Consultores, of course, Ricardo and Hugo. I also, I'm really happy to share the forum with Lauren and Orlando. And thank you so much, Silvia, for your moderation to this forum. Well, let me start by saying that there is one basic but undisputable truth at the beginning of these reforms. People usually ask that if the state has the sovereign faculty to establish all the reforms they want. And I said, yes, of course, state has a broad ability to regulate in these topics. But this sovereign umbrella, maybe, is not limitless. And in my opinion, arbitral tribunals can resist this authoritarian drift by refusing to normalize legal fictions and by adapting their standards of review to the institutional context of the host state. In authoritarian or quasi-authoritarian regimes where domestic institutions are no longer independent, tribunals must abandon the presumption of state good faith, one of the fictions, and the regulatory neutrality as a second fiction. Instead, and that's my opinion, they must scrutinize the intent, transparency, and procedural integrity of state measures. That means the tribunal should demand evidence, not rhetoric, when states invoke public interest. Applying proportionality tests, that factor is whether climate or industrial policy is used as a facade of favoritism or repression. And where necessary, acknowledging that regulation exercised in bad faith or for politically discriminatory purposes violates the core of international legal protections. Moreover, tribunals must open their proceeding to public interest, participation, of course, amici curiae, civil society actors, and affected communities. These voices not only provide legitimacy, but also reveal power asymmetries and political misuse of regulatory tools. In essence, arbitration can act as a retaining wall for legal rationality, even when states seek to bypass us or subvert international law. But this, and I want to be really emphatic on this, this requires tribunals to interpret treaty obligations as living instruments, not rigid formulas. Neutrality doesn't mean blindness. It means measured, principled resistance to arbitration, to arbitrary power. So I totally agree with pretty much that my colleagues have said before. But this reform that we are facing here in Mexico is designed not to enforce energy sector or to provide a better environment, but to hold the power, the control of the institutions, and diminish by itself the rule of law, actually, in all the sectors. So the tribunals can be like a wall to stop this, but referring only to the evidence. I mean, we had enough, actually, that everybody thinks that state always act on behalf of good faith. That's not true anymore. State has their own interests, and they are not always in favor of the society or the climate or the groups. Mostly, state focuses on their own interests, so the tribunals should scrutinize these legal faculties and maybe measured in a way that support the rule of law. That would be my take for now.
Definitely something to take into consideration, because we are referring that these tribunals come from, they do not belong to the government. They are just appointed to resolve this dispute. And how Professor Carlos is referring that the tribunals may be like these stop point for the reforms or for the situations that may happen. And that brings me to invite Orlando and then to invite Lauren, like having this into consideration, these reforms that had occurred at the beginning of this year, the change of government in the US, and the renegotiation of the USMCA approaching. And what do you believe or you expect for it to happen, considering what Carlos just referred to us about all these changes and the challenge that arbitrators may have in resolving these disputes. So, Orlando, what do you expect for the joint review of the TEMEC could result in the changes for the rules and procedures for the resolution and of investment disputes in North America? Definitely something.
To be honest, it's difficult to have a crystal ball, no? To see what will happen with this review. I assume that there will be some discussion between the three governments about this issue. I have read in the newspaper that the US is continue pushing or questioning the rationale of these reforms, but I don't have, to be honest, I don't have the details, and probably only the government has the details on how they will approach this situation. My impression is that if there is sufficient pressure from the industry, from the US, and from Canada with respect to these reforms, perhaps there will be some path to try to either to clarify or to, in some way, to provide better conditions to foreign investors. I agree with Carlos that many of the rationale of this reform is to maintain the control in some institutions and at the same time to provide preference to state-owned enterprises from the electricity and energy sector. But to be very honest, it will depend, I guess, on the pressure. If the US maintains this, I will say, this policy that they really, the main policy that they want to push is to secure that the manufacturer return to the US territory. Probably the energy sector or the investor state mechanism per se is perhaps it will not be the main, I would say, the top goal that they will seek. With respect to Canada and Mexico, well, at least they have the possibility to arbitrate these cases through the investment mechanism under the CPTPP, and there has been, I guess, one case about this that is using the CPP. I don't know if it's in energy, I can remember, to be very honest. But I also know that Canada has strong views with respect to the energy reform in Mexico, and I assume that it depends a lot in the pressure from the industries, from key stakeholders, to translate this pressure to the governments, so the governments can, I will say, act, no?
And Lauren, from the US point of view, which is the panorama you are expecting for this renegotiation of the BIT?
Bring the crystal ball.
Respectfully, I'm not sure that I can offer the US view on this question. I can offer my view. Maybe before I touch on the review of the agreement, I'll call it the CUSMA now, in deference to Canada's views on the naming of the agreement, CUSMA, TMEC, USMCA. Before doing that, though, to go back to Carlos's thoughtful comments about how tribunals can deal with authoritarianism, I think that tribunals under, whether it's the USMCA or many other treaties, are in an unenviable position because for most of sort of the last 80 years, there was a kind of a taboo on invoking national security or emergency powers in a liberal manner, right? That only in the most serious circumstances might you invoke, whether it's the essential security exception in the WTO or other police powers justifications in international law. And for many reasons, you know, that taboo is broken. And you see in all different types of cases, in cases involving natural resources, infrastructure, technology, telecom, insurance, I can think of many cases where governments are invoking these very broad sort of emergency exceptions of powers. And I think the challenge for tribunals here, and I think you hit on it very well, is, how do you distinguish between a government that is acting in something like good faith? We live in a world of very serious geopolitical challenges for governments. In the United States, for example, the executive branch is very concerned about investment from China, and not just in the United States, in the UK and Europe, I think here as well. And you see governments invoking these sorts of national security justifications, arguably in good faith, you could argue, but they're trying to solve or address these geopolitical related challenges. But then you have other situations which I think more clearly fit in the kind of bad faith category. And you have in the United States the administration declaring a national emergency with respect to imports of timber and pharmaceuticals, aircraft parts, auto parts. It goes on and on and on. And arguably, some of those policy measures, regulatory measures, are not in good faith. But as a tribunal, how is one to distinguish? And I think the treaties that we've negotiated do not help, as a general matter, tribunals to kind of draw this distinction between what is a good faith measure and what is something very different. And that is, I think, a challenge for governments going forward to try to better articulate these sorts of distinctions. Now, on the very important question of the review of the agreement, just I think it may be useful to mention on procedure, and this is sort of a U.S. point, that my understanding is that the United States had wanted to begin the review, the potentially renegotiation of the agreement, maybe in March and April of this year, but they have been overwhelmed by other responsibilities, including after April 2nd, negotiating agreements with many, many other governments to resolve the sort of reciprocal tariff issues. And so that review process has not begun in earnest in the United States. Under U.S. law, it has to begin by October of this year. Under the legislation that implemented the agreement in October, by October, no later than October, the administration has to invite public comments about the agreement, what went well under the first 6 years of the USMCA, what did not, what should be changed, what should not. And then in January, there's an obligation on the executive branch to report to the US Congress on its objectives in the review. But again, that hasn't happened yet. Maybe it will happen in the summer, but it hasn't happened yet. In terms of where the crystal ball, as Orlando said, what the review process looks like, and I want to zero in on the question of investment protection and energy and the Mexican energy reforms. I think there's no question that the constitutional reforms, the judicial reforms, the movement around the autonomous or independent regulatory bodies have resonated in the U.S. Congress. They've resonated in the White House, and they've resonated with U.S. stakeholders. I would strongly agree with the point that Orlando made that at the end of the day, I think it will depend upon U.S. stakeholders in Congress and also in the private sector. Do they view the reforms in Mexico as tilting the playing field in a way that makes investment in Mexico and the resolution of disputes involving investment in Mexico untenable? I can say from my own experience that I think there are many companies in many sectors that take that view. There may be other companies that prioritize other issues in the negotiations. So I think the sort of stakeholder views, which I think it's a bit too early to assess, will be very important. I will say that, and this goes back to a statement that I made in my earlier intervention, unlike in the first Trump administration, I do think that the second Trump administration is a bit more open-minded about using legal tools like investment arbitration to defend industry, to defend investors when they're faced with unfair treatment. I don't think that the USTR is quite as opposed as under the first administration. And also, I think you can look at how the improving, strengthening investment protection in Mexico would advance the objectives of administration. For example, you may be familiar with the term friendshoring, the idea of, in addition to bringing investment back into the United States, there is an interest in bringing investment into friendly neighboring jurisdictions. In the last 40 years, there's been no better friend of the United States than Mexico on economic policy, on trade policy, on foreign policy. And so I think you could see that being persuasive to the administration. And again, I would also mention that I think this administration does care that US companies acting abroad are treated fairly. And so I think you can see a world where the administration, if pushed by stakeholders, by Congress and the private sector, would look very closely at the investment mechanism in the agreement, in the USMCA, and attempt to improve it.
Definitely considering what you just shared with us, all these challenges that are going to be faced in the following months, and we will be following closely what happens and which is the criteria that the U.S. is going to stand up for this renegotiation of the USMCA. It's definitely something that all should be concerned because it has an impact in the economic situation of both countries. And well, going back to this point that Carlos was just referring at his first participation and the Mexico's recent energy reforms, I want to invite him to share with us what is his opinion about what makes the legal backlash particularly concerning from an international arbitration standpoint. How do these reforms test the limits of the so-called right to regulate?
Well, that's another crystal ball to imagine. And I guess this joint review of the USMCA would be an open door to significant changes in how investment disputes are resolved in North America. Unlike NAFTA's more open ISDS regime, USMCA greatly restricted access to arbitration, and just my colleagues explained it before. But this upcoming review is not just a technical checkpoint. In my view, it is a political opportunity to reshape the investment protection network framework. I mean, if the current trajectory continues, we may see further restrictions or even complete phase out of ISDS. Not a skinny one, it's a complete phase out of ISDS. It's a risk. However, growing investor concerns, particularly in response to Mexico's recent regulatory overturning in the energy sector, and I would add, not just the energy, but the judicial one, may create pressure to re-expand access to arbitration or introduce new procedural safeguards. In my opinion, ultimately, the review will test whether North America maintains a rules-based investment climate, or whether political priorities such as sovereignty narratives, industrial policy, or national energy agendas will further erode the mechanisms that provide neutral and enforceable dispute resolution. If investment arbitration is to remain part of the North American legal architecture, my take would be that it must reframe not as a constraint of state policy, but as a legitimacy-checking device that ensures regulation is exercised with transparency, consistency, and respect of international obligations. I will leave it at that.
Thank you. And Orlando, would you like to share with us your point of view?
Yes, based on this, and I want to follow up on what Carlos has mentioned, and at least to try to respond in some other way on this issue of the right to regulate and what happened with the case of the Mexico's recent energy reform, or the limits of this right to regulate. And I was thinking at least on what was reflected in the USMCA in Chapter 14, and probably Lauren will know better this issue, but it goes to my initial comment. I will say that this right to regulate in terms of the energy needs to be understood in these two type of policies. One is the phase out of traditional energy, and the other is the backsliding sources from adoption of green policies. No? So if you are modifying your law to not protect the green energy or renewable energy, perhaps you are in a different situation. But the Chapter 14 incorporates, and the USMCA incorporates many references to basically to secure that the three governments or the three states has this right to regulate this policy space. So it's in the 9th recital of the preamble. Is also incorporated in the Chapter 14. There is an article that is 1416 that relates to the investment and environment, health, safety, and other regulatory objectives. Some of the clarifications of key provisions, for example, the light circumstances test refers to a different treatment, but related to what is called in the chapter legitimate policy welfare objective. The expropriation, the indirect expropriation, there is a text there that basically says that non-discriminatory regulatory actions by a party designed and applied to protect legitimate public welfare objective, such as health, environment, do not institute indirect expropriation, only except in rare circumstances. So in my view, at least the chapter reflects the possibility that the governments can regulate, but the issue is whether they are regulated in terms of create a better system for the environment or that type of other tools. In the case of Mexico, the energy reform doesn't go to that way. That's my comment.
Thank you, Orlando. Well, now we have a few minutes for our panel, and we invite the audience, if any of you will have a question to ask the panelists, this will be the moment to do so.
If you don't have, we will ask you.
No? Well, maybe we
Ricardo.
can. Oh, please.
Thank you. Do you consider all these constitutional reforms in Mexico may affect the view of the U.S. as a friendly state, and this may move Mexico to another kind of list?
There are a number of tools that the United States has outside of U.S. trade agreements that the United States is increasingly using to restrict trade and investment based on foreign policy or national security concerns. You've seen, some unusual measures in this administration. You've seen, for example, in the first week of the administration, when the government of Colombia refused to accept 2 plane flights of deported Colombian nationals, the President Trump threatened to impose tariffs on Colombia of 25% if they didn't do so. And so could you imagine a situation where, the United States disagrees or objects to the position of the courts in Mexico as a result of the judicial reforms and decides to use measures, whether tariffs or lists, as you say, restrictions on investment or sanctions or export controls or other things? I think we're very early to say, to be honest, that 4 months in, the U.S. ambassador to Mexico just took office this week. Senator Rubio, Secretary Rubio, has a lot of experience in the region, but is fighting fires, I think, everywhere at the moment, is maybe not as focused on Mexico as he will be later in the USMCA review. I mentioned already USTR, that they're busy with negotiations with 57 governments. They're not so focused on Mexico. And so I think it's too early to say. The only thing I would say, though, in the crystal ball, is that this administration has shown that they're willing to use untraditional tools to advance their interests. So I think you have to look at the administration from that vantage point when you think about if they determine that they are concerned with the judicial reforms, then the range of tools that they're willing to use, both economic tools and other foreign policy tools, are much greater, broader, more aggressive than the tools that we've seen in previous administrations.
Well, I thank you for your interventions, and you give us a lot of food for thought. And I had a lot of questions, but I'm going to limit them to two. The first one relates to, Lauren, you have mentioned a lot this national security issue. Now, as you know, there's a big debate on the trade arena on the national security exception. And really, when you read some of the awards on investment, aside from some Argentinian cases, we have dealt with national security. There is not a lot of that on the national security now. And this is for you. Do you think this will be a game changer once there is a serious discussion on interpretation of a national security exception in an investment agreement? And what will be especially the U.S. take on that, especially given what we have seen in the trade arena on the U.S. view on national security? And would that, I'm talking about a game changer because at the end you don't know if tribunals start taking the U.S. view, for example, that this is not justiciable, then what would be the future of investment cases if that is the case? Now, that's the first part. The second one relates to, I mean, there is a lot of discussion on this regulatory autonomy, and as far as Mexico, we have not seen really a case that deals with regulatory autonomy, even in the energy sector. As far as I recall, and as far as the government have made public, because some of the things we don't know because the government is not making public these arbitration notices, we only know of one case of energy related to energy that really doesn't deal with regulatory autonomy. It's basically complaint between Pemex and an investor of relating to a oil pipe, of who gets the operation of the oil pipe. So I would really, and given U.S., and I'm talking of U.S. investors, of U.S. views on energy, I wonder whether really we will have this trend of cases, or we all been saying for the past 10 years that there will be a wave of gay cases against Mexico, and we have not seen it. And what we have seen is U.S. and other countries' investors really trusting the judiciary and going for the judiciary. Maybe that's another discussion, and we have a table session on that. But my sense is, given the trends that we're seeing in the world, will we really be engaging in the same discussion the way these scenarios are changing? And I will leave it like that. And again, thank you to the four of you for the session.
Waiting for your third question. Those are very good questions, very important questions. I'll offer my view on the questions. On national security, you know, it's a very interesting situation because in the WTO, you have a particular type of exception, as you know very well, that WTO panels have now found is subject to review. When a state invokes essential security, it's subject to review, rejecting the historical United States view. Now we have a situation where the WTO is not likely to resolve disputes at the appellate level, for the foreseeable future. But in the investor-state world, you do have 3,000 treaties, 2,500 treaties in force that have the potential to result in disputes involving the invocation of national security or essential security. And you have a wide variety of different types of exceptions. You have some treaties like the USMCA that has what the United States describes as a self-judging exception, meaning it's non-justiciable. You have other treaties that say nothing, where US-Argentina, I believe, all you can fall back upon is customary international law, necessity, defenses, police powers. And you have treaties in between that have a wide variety of different approaches of exceptions and exceptions to the exceptions around national treatment and others. I will say from a US perspective, I posed the problem earlier of, you have states that have these very tricky situations and they don't want their national security related decision-making to be subject to review, right? And then you have investors that have, major investments, capital in the ground, that can be vulnerable when a state invokes these exceptions or space too broadly. I will say that with respect to treaties that have so-called self-judging exceptions, I can't think of the name of the case right now, but there was a recent case involving I think it was the US-Colombia Free Trade Agreement, which not only has a self-judging exception, but also has a footnote to the self-judging exception that says, this means tribunals that you may not review the invocation of this exception. And a tribunal recently still decided to review I think it was the Colombian government's invocation of the exception, finding a kind of good faith path, maybe inspired by Carlos's comments here today, found a way to evaluate that space. At the end of the day, I think that there will be decisions, and this decision might be a game changer, even though I can't think of the name of the decision, that challenge the way that treaty parties that drafted these treaties with a certain view of how to treat national security will challenge those views and result in a reassessment of what states and treaties need to do in this space. But I think there's just a much greater problem here that treaties were not developed, the 2,500 treaties in force were not developed with a view to the very complex geopolitical environment that we have today. And you see governments, I think, amending their treaties, updating their treaties. In North America, we have an opportunity to do so in the USMCA review. I think it's the challenge of the next generation, and then the question of what do you do with these residual treaties that don't provide a whole lot of guidance. I've spoken a lot. On the second question, maybe we can talk about it afterwards. I want to make sure that others can speak.
Want to? No? We still have time for another question if any one of you is interested. Guillermo? Mm-hmm.
Well, thanks, first of all, to the four of you. It's been a really interesting panel. But my question is more directed in cases if you're counseling an investor that wants to bring his capital to Mexico under this new regime, and taking into consideration the superpowers that had been just granted to the Mexican Ministry of Energy, sorry. What would you counsel your client in this matter like? I can see how it's intimidating to have to deal with an authority that has so many powers. So in this case, how would you protect your client or your investment to this new regime and this fluctuating economy changes and the regulatory dangers that this authority poses?
I have something in my head, but I don't know if you agree, but I think that obviously your client and you need to prepare this due diligence report, basically reviewing every single aspect and provide all the description of the tools that they have, but particularly they need to see whether they are able to make business in Mexico vis-a-vis what the current scenario. But to be very honest, some of the investors sometimes want to make this investment for a long time, and they know that there will be some changes in the future, and they need to, I would say, wait what is better. But at the same time, it's good to know what tools they may have, either the type of investment that they have, whether there is a bilateral investment treaty that provides better tools for the investor in case of some changes from the government, or whether there is a contract there, what type of, I would say, arbitration clauses they want to use. So there are many layers, but I think that there is still room vis-a-vis the situation that Mexico is facing to make business. No? I don't know if someone.
I would just add, I'm not myself a legal counselor or something, but well, I agree when on the due diligence thing, but one thing is important from now on. Once the judiciary is getting weaker, arbitration is getting stronger at the same time. So most of the law firms would focus more and more on arbitration itself. So in case your client has contracts, you should be really careful on the arbitration clauses. And of course, if there is contracts with governments, it's not really feasible to establish the stabilization clauses. So, I mean, not anymore, not recently, but that would be one absolutely great alternative. But tribunals, arbitration tribunals should focus a little more on these limits of the state. Even when I agree with Ricardo that we don't have much cases of this, it doesn't mean we won't have, because the recent Mexican reforms are justified on energy sovereignty, which is a totally it's a tailored suit for Mexico, and they're focused on the sovereignty itself and the right to regulate, and it is not enough to protect the Constitution or our laws. Government should focus a little more on justify its measures, and if authority doesn't make it, it would be a lot of suits. That's my take.
Well, thank you, everyone, for your answers. We are reaching our ending point for this panel. I just want to refer that all the panelists have shared with us their point of view, and we should be taking into consideration that we are part of this change in the practice of energy and in arbitration, either it's commercial or investment. So definitely we are the characters of this play, and we should be taking into consideration that our practice will definitely have an impact on what should be decided and said in investment or commercial arbitration in the following years. I would really want to thank all our panelists, Dr. Carlos Reyes Díaz, Orlando Perez, and Lauren, for sharing with us your time, your experience, and your point of view, and also to the organizers for having this panel and letting us have the opportunity to listen and learn from such outstanding colleagues. Well, hope you have a really nice morning. Thank you.
Thank you.
toca doble.
Te toca doble, sí. Hola, buenos días. Hola, Andrea, ¿cómo estás? Hello? Okay. Yes. Good morning to everyone. Thank you for joining us today to the World Arbitration Update. Thank you to RRH and all the organizers here in Mexico City. It is a true honor to moderate this panel with these great experts and an important discussion title is the Mexican Judicial Reform, a Denial of Justice under the Fair and Equitable Treatment and Minimum Standard of Treatment.
And as many of you know, there are recent proposals for the judicial reform in Mexico that have sparked intense debate, both internationally as well as domestically. And from the investment law perspective, these developments raise serious questions about whether this reform would entail to denial of justice or potentially triggering claims under the fair and equitable treatment standard or the minimum standard of treatment under international investment agreements. So now, today, we are very fortunate to have an outstanding panel of experts to help to navigate under these complex issues and discussion. And I will introduce, first of all, the panelists today. I will start with Andrea Ornelas, who will be the presenter and will give us an update of this matter. Andrea is a senior associate attorney at RRH Consultores and holds an LLM on international economic law and policy from the University of Barcelona. Since 2012, her practice has focused on international trade law, particularly in providing legal advice on issues related to compliance with the WTO cover agreements, NAFTA, and domestic trade law. In her practice, she has also served as counsel in matters of unfair trade practices in anti-dumping investigations, reviews of anti-dumping duties, and sunset reviews. Since 2022, she has focused on providing legal advice on issues related on investor-state arbitration. Now, Eduardo Siqueiros, after having practiced in Barrera, Siqueiros y Torres Landa, a Mexican law firm which merged in 2014 with Hogan Lovells, Eduardo retired in December 2018 to act exclusively as independent arbitrator in international commercial and investor-state disputes. He has been a professor at various law schools in Mexico and a frequent speaker in multiple fora, local and abroad. He received his law degree from Escuela Libre de Derecho and an LLM from Harvard Law School. He is an advisory member of the International Council for Commercial Arbitration and a founding member of the Mexican Arbitration Institute. Gabriela Álvarez is the co-leader of the Latin Arbitration Practice Group. She focused her practice on international arbitration as well international and investment law. She is experienced in complex and high-stake transactions related to infrastructure projects, banking, electricity, telecommunications, and oil and gas. Gabriela has represented investors, states, governmental entities, and state-owned companies in international arbitrations under the ICSID, UNCITRAL, ICC, London Court of International Arbitration. She has also acted as arbitrator in arbitrations under the ICC, UNCITRAL, and CAM rules. Gabi has designated in the ICSID panel of arbitration for Mexico. She is also the former chair of the ICC Mexico Investment Arbitration Committee, a member of the CAM Arbitration General Council, a former member of the Canaco Arbitration Commission, and a member of the Instituto Mexicano de Arbitraje, and a founding member of Abogadas MX. And Dr. José Ramón Cosío, he has an extensive and distinguished background. With his permission, I have taken the liberty of summarizing just a few of the most relevant highlights from his remarkable experience and career. He studied law at the University of Colima, completed a master's degree in constitutional law and political science at the Center for Constitutional Studies in Madrid.
followed by a doctorate at the Faculty Law of the Complutense University of Madrid. He also obtained a master's degree from the Faculty of Law of the National Autonomous University of Mexico, here UNAM. He has divided his professional life between academia and public service. His main area of research is constitutional law. He served as Justice of the Mexican Supreme Court of Justice of the Nation from December 1, 2003 to November 30, 2018, assigned to the First Chamber. He ruled on cases involving human rights, crimes, contracts, administrative law, liabilities, and corruption. Currently, he is a distinguished professor at the Monterrey Institute of Technology and Higher Education, ITSM, heading the Observatory for the Constitutional Reform of the Judiciary in Mexico. He managed the Institute for the Strengthening of the Rule of Law, formerly presided the Mexican Institute of Mediation, and coordinated the Mediation Committee of the Mexican section of the International Chamber of Commerce. He has served as an arbitrator and mediator in the national and international disputes, and have been a board member of several nonprofits institutions such as Grupo Financiero Citibanamex and Banco Nacional de México. He regularly collaborates with media, Aristegui Noticias, Leonardo Curcio, Grupo Fórmula, and writes for El País and El Universal, and he has coordinated and compiles numerous books and authored 41. His latest book is Corruption in Mexico, un acercamiento al siglo XX desde la perspectiva jurídica. As you can see, we have a great experts here today. Many thanks for everyone to being here today. To start, I will start giving the floor to Andrea to give us an overview of the topic and set the stage of this discussion. Please, Andrea.
Thank you. First of all, I want to thank the organizers for the invitation. I will begin my presentation just talking a little bit about the FED standard in general, its relation with minimum standard of treatment has been discussed in several investment cases in relation to whether FED is included on MST, on whether it entails a higher protection, on whether it's autonomous or not. I will not delve into that, but I will focus on three main points that I think frame the discussion about whether a specific measure can breach the FED standard. And that is, first of all, the text of the specific provision at issue. And this, of course, means the ordinary meaning of the text, the context, the object and purpose of a treaty. Second, the content of the obligation, and this relates to the conduct that will be deemed as potentially breaching the standard. And this really shapes the legal standard that will be taken. And finally, the application of the legal standard to the facts of a given case. I include here some examples of how this obligation is usually framed rather shortly. And for example, the first two are rather standard, include a rather standard language. And the last one, for example, specifying without a doubt that FED does not entail an additional protection. It does not entail additional substantive obligations. As to the second one, the types of conduct that through case law have been deemed as breaching this standard, we can talk about arbitrariness, discrimination, lack of transparency, lack of due process, and of course, denial of justice. When framing this standard generally, and a little bit focused on judicial proceedings, tribunals have described it as conduct that is manifest injustice, which offends a sense of judicial propriety, a manifest failure of natural justice and a gross denial of justice. So the language used really points to a high standard. But how has denial of justice been understood? I refer to 3 known cases. The first one, Asinian versus Mexico. Here the tribunal really gave examples of what denial of justice of what type of conduct can result in denial of justice. And it's, for example, that a court refuses to entertain a suit, that the claimant is subjected to undue delay, or if justice is administered in a seriously inadequate way. In the second one, Mandell versus the USA, for example, the tribunal framed it as a question and highlighted that taking into account the generally accepted standards of justice administration, if the measure was clearly improper, clearly discreditable. And finally, a really important case in my view, LMC versus Mexico, where the tribunal, taking into account the case law, previous case law, determined that a positive finding of denial of justice requires an improper and egregious procedural conduct, something that does not meet basic standards, something that shocks or surprises the sense of judicial propriety. So here, taking into account also a little bit what has been said about arbitrariness. And in this case, the tribunal made it clear that, for example, what is encompassed by denial of justice is really access to court, the ability to be heard and to present the case, and the right to obtain a decision without undue delay. I want to address also two cases where this standard was analyzed. The first one, Joshua Dean Nelson versus Mexico. And here, for example, the tribunal also indicated that a mere disagreement with the court does not entail a lack of reasoning. It does not imply that justice is administered in a seriously inadequate way, or that the courts clearly and maliciously misapplied the law. And this also relates to the fact that bad faith, for example, is not a necessary element for a finding of breach. And of course, LMC, which I already referred to, where the claimant was found to have been wrongfully denied the right to appear before the judge, the right to appeal because of a improper procedural decision, and the fact that repeated requests in order to present evidence and allegations that it had been subjected to a sophisticated fraud were never allowed. Having framed a little bit how the standard has been shaped through case law, I want to just briefly point out, certain changes that have been introduced with the Mexican judicial reform, which was approved last year. Some of these changes really are profound in terms of the administration of justice. I refer just to some of them. For example, the reduction in the number of judges of the Supreme Court, of ministros, the reduction in term of office, the binding nature of decisions of the Supreme Court by a majority of 6 votes, the creation of the Tribunal of Judicial Discipline and the Judicial Administration Body, the term given to solve a little bit quicker cases in fiscal matters and also criminal proceedings, and two other issues that have been mostly discussed, which is the election of judges through the popular vote that will take place this June, and the establishment of this figure, jueces sin rostro, faceless judges, in cases of organized crime. So with these with this general overview of these 2 issues, the discussion today really aims to exchange views on how the conduct of the administration of justice can impact compliance with the FET obligation, or with minimum standard of treatment, which really is the floor set by customary international law, when we look at them through this lens. with this, I finish my presentation, and I yield the floor to the other panelists for a further discussion. Thank you.
Thank you very much, Andrea, for this excellent introduction and for giving us a very good perspective on the legal standard, as you mentioned, set by the customary international law and the citation to those cases where this standard has been analyzed by the tribunals. And of course, the changes, the main changes adopted 8 months ago, I think so, when the judicial reform was approved. So let's move deeper into the legal standards to frame our discussion today. And I will start with Eduardo. Andrea has already mentioned that this standard is limited or defined by customary international law. And I would like to ask you, Eduardo, under customary international law, particularly under the fair and equitable treatment and minimum standard of treatment obligations, what are the key conditions and legal requirements for a judicial reform, like the one that we are discussing, to be considered as a denial of justice?
Thank you, Cindy, and thanks to the organizers of this event for inviting me to participate. I'd just like to make one disclosure, and that is I currently have the privilege of participating in 2 arbitral tribunals, one of which involves Mexico, that examine the issue of denial of justice. So I would just like to make it clear that I will not discuss either any of the facts of those cases or any of the issues in those cases here. I think we have plenty in historical background and other current cases from which we can examine the topics that you address. So having made that disclosure, I'll continue. It's an interesting question, Cindy, because you don't have, denial of justice is not a codified concept. It's an ever-evolving concept. When you think about denial of justice, one of the cases that was emblematic in international law was one that gave rise under the U.S.-Mexico Claims Commission in the early 20th century, which was, many of you might recall the case by name, Near versus Mexico, which was a citizen of the United States of Mexico, which was killed in some event, and the United States brought a claim against Mexico on behalf of the widow and daughter, claiming that justice had not been made through proper investigation of that case. The relevance of that is that for many years the standard was high, and it stated that in order for this case, in order for a denial of justice to exist, there had to be, and I quote very rapidly, this should amount to an outrage, to bad faith, to willful neglect of duty, or to an insufficiency of government action so far short of international standards that every reasonable and impartial man would readily recognize that insufficiency. And this case was quoted, and sometimes it's continued to be quoted in cases, but denial of justice has evolved. When the NAFTA treaty was executed, after certain cases started coming out from claims being brought, and these were attempting to expand the concept, the Free Trade Commission made a statement and said, oh, no, what the three countries, this is a free trade commission, was commission composed by the three members, Canada, United States, and Mexico, said, no, what we mean about these standards of treatment is this, and it should not go beyond customary principles of international law. So what does this mean? In short, what you have to take into account is what is under the principle judicial legislation of the world. Some of you might recall that when the United Nations was created as a successor to the League of Nations, there was a term that was used of the legislation, the principles of civilized nations. Fortunately, that has been abandoned. But the standard is, what do the legislations, the principles of judicial establishment, legislation, procedure, the principles of law under these main countries in the world, what do they establish? And what they establish, in essence, are, one, it has to have a due process. It has to take into account the views of the parties. And we can cite some cases later on as to why denial of justice has been considered to not be present when those when a party is not being permitted to participate in the process. But one of the cases that I still believe is valid today is a principle that was established by Sir Gerald Fitzmaurice, who was a judge at the Permanent Court of Arbitration and in the International Court of Justice. And he stated that, judicial error can exist. Sometimes the error might be more serious than in others, but what cannot be tolerated is the absence of a system that provides justice. This is, you can tolerate judicial error, but you cannot tolerate judicial incompetence. And a system that does not ensure judicial competence is a system that denies justice. So what does this come back to your question, Cindy? Because we could have hours of discussion. This is, if judicial reform does not provide the basis for a competent judiciary in Mexico, one that is capable and provides a proper due process to the parties, that will be a breach of the standards of treatment under treaties established by Mexico. We have many, but I don't want to take too much time on the floor, and we can come back to some of these elements later.
Thank you very much, Eduardo. Interesting. It is not a codified concept, and it's an evolving concept. And in terms of how does this the judicial reform will entail in terms of the compliance of this provision, due process is a core element to evaluate whether this reform would entail to a breach of this standard. Now I will move to Andrea. Andrea, building on Eduardo's point, could you comment on whether such reform by itself could constitute a breach of the USMCA or other investment treaties? And do you think that the USMCA give some specific protections that would apply to this kind of state measures. For instance, the reform that is under discussion in our panel?
I would not say that the reform by itself results in a breach, but what can breach the Fed standard are specific actions by the courts, specific conduct that precisely results in access to the administration of justice, procedural errors that are really substantive, and undue delays precisely how, as I had mentioned before. So really, what I think we need to do is to wait and see how the law is applied in order to actually see the conduct of the system under these new rules that have been established. And also an important point is that if we're talking about Fed, then we're talking about a treatment that is accorded to covered investors which are owned by an investor. So these are also two elements that need to be present for a breach to be determined. As to protections in the USMCA, I think that the states actually remain sovereign and still have autonomy to regulate their internal matters. So I would not say there's like a specific protection as to the state reform.
Yeah, Eduardo, do you want to make
Yes, just
comments, please?
A brief remark in addition, because Andrea is right. We have to wait and see what the outcome of this judicial reform is going to be. But one thing is clear, is the responsibility of the state to establish a proper functioning judicial system. If the process by which the judges, and these are federal judges that we will be electing in just a couple of weeks from now, not local judges. These are the key part of the judiciary, at least from my point of view. The column, the center of the judiciary of a country is what we will be electing in a couple of weeks. If the government does not ensure that these elected individuals which were selected sometimes at random, by chance, do not have the proper qualifications to judge, to decide, that's where we're going to risk a breach of the duty under international treaties.
Thank you, Eduardo. And particularly in terms of, for instance, the NAFTA provides that there would be the exhaustion of local remedies before submitting a claim to arbitration. So this is something that we will need to see in the application if that courts will be really effective to solve the kind of disputes that may arise from under the NAFTA, under the USMCA. Sorry, no NAFTA. Okay, now let's move to the substance and procedural issues of this standard, which are at the heart of the most of the denial of justice claims. And in international investment law, tribunals have made distinctions between both the procedural denial of justice and the substantial denial of justice, which involves outcomes that are manifestly arbitrary, egregious. You have already mentioned about this. But sometimes these two dimensions are not distinguished very easily. So particularly in the context of this judicial reform, Gabi, because, for instance, changes to the court structures, to the appointment of the judges, or constitutional remedies may have procedural implications as well as substantial implications. So, Gabi, I would like to ask you, in your view, what is the difference between a procedural denial of justice and a substantial denial of justice in the context of this judicial reform? And in your view, which type of violation is more likely to arise from the current Mexican reform?
Thank you, Cindy. I'm actually very happy to be here again at my alma mater in the UNAM. I had not been here at the Instituto de Investigaciones Jurídicas, I think, for at least 8 years. So thank you for the invitation. Thank you for the organization, to Ricardo and the whole group, as well as World Arbitration Update, and to the Instituto to be the host of this event. I'm going to start by addressing this, what is the content, both at the procedural level, at the substantive level of denial of justice, and then I may make some additional comments based on the previous discussion. But investment arbitration case law has usually framed denial of justice under 4 categories, the same categories with which the customary international law concept of denial of justice has developed. First, delay leading to excessive long proceedings, denial of access to court, due process claims, encompassing serious procedural defects. These 3 categories relate to states' obligation to afford due process to foreign investors involved in judicial proceedings, and those fall within the procedural violations category. Then the 4th category concerns an irrational or abusive outcome going beyond mere misapplication of the law and pertains to content of a court's judgment against a foreign investor. Excessive delays. International tribunals have long agreed that justice delayed is justice denied, and that's what exactly the Lyon case actually confirmed. This principle is also generally recognized in the national judicial systems. And of course, no specific amount of time serves as a yardstick to determine whether a given delay constitutes a denial of justice. And I have to say that it would depend very much of the facts of each case. But let me give you an example. For instance, in Pay Casado versus Chile, the tribunal found that a 7-year delay constituted a denial of justice. And I would say that in many cases, this time frame would vary between 5 to 9 years. Denial of access to court. It is widely also recognized that the right of access to courts or other adjudicatory bodies is a basic aspect of due process, and that refusing such access constitutes the classic case of denial of justice. Access to court may be denied by in different ways. For instance, procedural defects such as purposeful disruption of commencement of the proceedings, or even the absence of notification about proceedings that exclude the possibility to challenge them, could all result in denial of justice. And this is something that was confirmed by, again, in the Lyon case, in which a failure to notify claimant was discussed thoroughly, but also in the Mohammad Ammar versus Tajikistan case. Then the third procedural aspect is serious procedural defects. There can be a variety of procedural defects. Among such procedural defects, the violation of parties' right of defense, including the right to present evidence. And this is a question that stands out when one analyzes serious procedural defects. The Lyon case is also relevant for this point. It seems that in Lyon, a lot of things occurred. They had the whole panoply of possibilities there. There, the tribunal found, and I'm quoting, in the course of local proceedings, Lyon tried on multiple occasions to bring relevant evidence that could easily prove the illegality of service and justify the annulment of the cancellation judgment. However, the municipal courts repeatedly denied Lyon the possibility to do so. And finally, the substantive violation, malicious application of the law. In addition to protecting foreign investors from procedural misconduct, denial of justice affords protection against the improper or malicious application of the law by the host state's courts. And I'm going to cite again, I think it's as actually efficient to do that when a tribunal has summarized the concept effectively. The tribunal in Malunium versus Belarus said the violation of domestic law does not by itself constitute a denial of justice. So mere error doesn't make it. A judicial error does not give rise to a claim for denial of justice. Incorrect application of the law does not constitute denial of justice. Otherwise, aliens would be afforded a new opportunity to appeal once all local remedies have been exhausted. Denial of justice requires a clear and malicious misapplication of the law, a specific mens rea, the will to wrongfully apply the law against the alien, frequently evidenced by a willful disregard of due process. And I would just put for discussion whether, for instance, a judgment that on the one hand affirms certain principles and bases decision on certain application of the law, and then in the same judgment disregards it, could basically entail a malicious application of the law. And I would say yes, because that would say the judge is aware of what the law is, and in one part of the judgment applies it, and another disregards it. So that could be a malicious application of the law. Now, as to which of the above violations could occur in the framework of the Mexican judicial reform, and as we all agree at this stage is obviously a guesswork because we still don't have the judges deciding cases, but we are in front of an unprecedented reform for at least two reasons. It is the first time a change in the number of judges of this magnitude is taking place, not only in Mexico, but I would say in the world. And there will be likely a number of those new judges that do not have judicial experience. My guesswork is that this could cause more delays than the ones that exist today in the judicial system. The lack of experience could also bring violations of access to justice or violations of due process. Although the substantive violations could occur, as the standard clearly indicates, simple errors are not enough for a denial of justice to occur. Now, I just wanted to make one clarification, which I also think it's an interesting question that, to my knowledge, has not been raised in a case. You, Cindy, mentioned the condition in USMCA to bring, before starting an arbitration, to bring the claim before the judicial system, the tribunals, the local tribunals, for 30 months. That's a condition precedent for submission of a claim. Now, what would happen if basically the claim is denial of justice and the judiciary or the judicial avenues have been exhausted? Well, then how even the investor could actually be required to go before local courts, and which would be the tribunal to actually hear such a claim? I think that's going to be a very challenging aspect of that treaty, in my view. And I leave it there.
Thank you very much, Gaby. Very interesting, and thank you for posing these questions. Dr. Cosio, I will turn to you the floor.
Exactly about what?
I think that you will have a lot of comments on what Gaby has already raised.
No, I think it's a very good. Thank you very much for the invitation to Ricardo, and it's very nice to me be here this morning in this institute and in this place that names Héctor Fix-Zamudio, who was my professor and mentor. It's very, very important for me. I think Gaby put in a very, very clear way what is or what will be the problems with our actual situation in Mexico. I think that the judicial reform by itself don't produce the negation of justice in itself in national or in international terms. I have only two concerns. What is about, Andrea said, the faithless judges, because the decision of the Court of Human Rights in Costa Rica, and Eduardo Ferrer is here, was declared unconventional in several cases related with Peru. And the other problem is the lack of remedy against the decision of the Judicial Discipline Court. I think are both constitutional problems, but any of them are related with the investment. No, it's very difficult that all those cases are related with investment in the cases that we are talking in this moment. I think the presentation of Gaby is very important in the sense that it's possible that in the future cases that will be resolved by the Mexican judges in the several levels, national or local levels, will be in delay, in denied, not by the reform by itself, but by the result of the reform. No, the delay is for me one of the first concerns. The Supreme Court now don't assign the cases to the actual justice. The chambers will disappear, and another kind of problems. The general problems in Mexico with the delay of justice, of course, is very problematic in the near future. The other, of course, is this kind of the common errors, and maybe it's an hypothesis. What will happen if the new judges assume that they are part from a political party, a political movement? I don't know what will be this kind of results, but maybe it's only an hypothesis. The new judges in general can say, well, I am designated by the people. I came from a popular election. I am a member of this movement that names by itself the fourth transformation, and for that reason, my decision don't be related with law, but will be related with the popular design, the popular impression. I don't know what is the future in this concern, but it's possible, and I said only that is a possibility that in those cases, the malicious application that Gaby said is possible. I, like a judge in the near future, don't apply the law in the terms of the many important things that Eduardo and Andrea said, but I apply the law in a ideological, in a political, whatever expression in this sense can be taken. And for that reason, in these cases, the Mexican legal system have several concerns. This is my first approximation to this problem.
Thank you, Doctor. On what Gabi has very well explained, the procedural and substantive warranties or differences. In your experience, in your vast experience, as you are aware, we have also had an amparo reform approved. Might the restrictions on amparo may affect both procedural or substantive outcomes in terms of what Gabi has already explained it to us?
I don't think so. The judicial reform to amparo reforms that was make it the last year, I don't, in general terms, restrained the effects of the judicial decisions. No, this is another problem with the actual judicial reform. This judicial reform don't make any changes, big changes in the procedural questions. It's an organizative, it's an a structural reform, but in terms of nomination, designation, votation, this kind of questions. But in general, don't make big changes in the procedures, in the amparo procedures or in any other procedure. This is an important point for critique. The former President López Obrador said, well, this reform will support the necessities of the people, whatever. Really, this reform is not related with the necessities of the justice of the people, or with the terms of designation, with the quality of the product. For me, it's a very personal point of view, is a reform that try to take the judicial power and submit the judicial power to the political procedure. This is my personal point of view. But in that sense, the amparo reforms, I think, don't be and don't will be and produce an affectation to the general system. This is my perspective. In the near future, in the next year, for example, when the new court was organized, whatever, I think in this moment, maybe will produce many results, many affectation of the sense that Gabi tell us this morning.
Thank you very much. Well, now let's move to another topic that is related with this, an essential element of FET or any denial of justice claim, that is the requirement to exhaust local remedies. And this is not just a procedural issue. It is deeply related with the definition of denial of justice. And arbitral tribunals under the NAFTA and other investment treaties have consistently affirmed that the denial of justice does not arise merely from an adverse or a flawed judicial decision. And this is something that the panelists have already mentioned. Instead, they must prove that the domestic legal system as a whole failed to provide an effective redress. So in this sense, Andrea, could you explain what role the exhaustion of local remedies plays in establishing a denial of justice claim under customary international law? And what is the threshold to demonstrate that local remedies have been exhausted or are futile?
Okay, so the role, as you said, it's fundamental for the pursuit of a claim to denial of justice, or for it to be successful to exhaust domestic remedies. And the reason for this is like you said, you have to show that the system failed. So Gabriela spoke of errors, and not every error results in denial of justice. So the system has to be given an opportunity to correct the violations or to address them. And that's why, in general, yes, exhaustion of remedies must take place. However, there's the exception of there have to be remedies that are reasonably available. So that is one exception, and the other one is if the remedy is futile or not. What is the threshold? I would say is case law has referred, for example, to there must be an expectation or a prospect that the remedy will actually correct the wrong, that it will be effective in addressing the violation. And that is, for example, also something that was discussed in LMC versus Mexico. It was one of the arguments made by the respondent that the claimant had not exhausted the local remedies, and the tribunal basically said, no, it did. It went to the highest court. It used the remedy that was most suitable to undo the cancellation of the mortgages. And on top of that, there was not really a prospect that the claimant was going to, that the error was going to be corrected, because a certain time had passed, like 3 years, and the case had been remanded to a judge that had already taken an adversarial position, and no evidence about the fraud, the forged agreements had been considered. So essentially, the core of the claimant's allegation as to the loss of the investment was gone. And this is why there was no prospect. So I would say this is the threshold on this issue.
Thank you, Andrea. Gabi, do you have any comments on this? Would you agree on what Andrea just mentioned? And could you help us to understand how factors such as excessive duration, corruption, or judicial bias are assessed by arbitral tribunals?
I totally agree with Andrea. I think another aspect on exhaustion of local remedies as part of denial of justice that should be considered is when excessive delays never results in actually in a judgment, right? Because if you don't have a judgment, there's nothing to appeal, etc. So what would be the next? There would be. It then goes back to the point of whether there is available or effective remedies. And the second point I want to comment on is that denial of justice, the nature of denial of justice generally is considered to be a creeping FET, in the sense that normally one act of the judiciary rarely would occur in a denial of justice. You would need to have several acts to be considered to then a breach to materialize and occur. And it's the aggregate of those actions, whether they are violations of due process, delays, or shocking findings, that would basically result in a denial of justice. For corruption, I would say that that's a very difficult question to prove, generally speaking, whether it's denial of justice or not. I think the corruption within the judiciary is even more difficult to address, and here it's more my personal recent experience in dealing on how the judicial system works in Mexico that makes it, for me, even more difficult. I think, and I'm sorry maybe if there are some litigators in this room, but when I have a denial of justice case now pending in which I'm representing the investor against Mexico. And not the same in which Eduardo is, by this. It's a totally different one. And what I realized is that the system, the Mexican system, have very real problems. Like counsel would not only fight against the other side, but against the judge. Like you have to defend yourself against the judge, and that's the strategy. I think that just makes it evident that the system is not functioning, or whether a party takes a position that if judges make errors or are delaying the process or are not taking decisions, it's to the party to move forward the proceeding because the judicial system simply doesn't work, makes, again, for me, evident that there is an evident problem. And rounding back to the point of exhaustion of local remedies, if that's the case, maybe we will basically reach a point in which there's no effective remedy. Or the remedy available was so much delayed that maybe the destruction of property occurred. It has advanced to a point in which not even the granting an amparo could actually reverse what has happened, and then the remedy is not effective. So those are some of the considerations that one needs to, or a tribunal would need to wait in a specific case. Yes, I think I answered your question.
Yes. Yes, thank you very much. Thank you very much, Gabi. A very good answer on this. We are approaching to the end of our panel, our discussion, and let's zoom out and look at the broader picture of what lessons can be drawn from investment arbitration practice regarding the systemic judicial failures in the NAFTA region, as well as in other countries. Dr. Jose Ramon, could you share some examples of cases where tribunals have discussed systemic issues in national judicial systems? We have already heard cases related to the analysis of this standard, but in general terms, the issues where tribunals have already addressed this kind of systemic judicial issues?
Eduardo, Andrea, Gabriela was named the Lyon cases, the Nelson cases. But I think the most important thing, and I agree, of course, with Andrea and Gabriela, is in this particular situation, two questions, or three questions. First of all is that each case need to be reviewed in his own particularities. No, you can say, well, because this case is agrarian or civil, or no. Each case has his own procedural terms, procedural time. This is very important. The second one is the construction of the legal standard, because we said, well, the denial of justice, the lie of justice. Okay, this is, but what are the specific question in different cases? And the third, and is very, very important and is very complex, is the evidence that you can that can support your concern, your demand against the other cases. Because Gabi said you need to break this vicious circle, because you don't receive or you don't are in the judicial procedure because the judge maybe for corruption, maybe for the number of cases, whatever, don't resolve your own case. And you need to finish this procedure. In what moment you can break this general rule, and in what moment you say, okay, I try to do my best in this country, in those procedures, with my, and the general system don't function, the judges don't resolve. What is the moment and what is the evidence that you say? The similar cases, different cases. I think this is a very, very interesting reflection. And I think, and I understand that in the whole countries have exactly the same problem. Maybe the specificity of this one is this or this one. But in general, in what is you are authorized to say, well, that's enough in this country, and I need to level my own concern. I think is a problem of three components: the particularity of the case, the evidence in each case, and the legal standard that permit that you left the Mexican system or whatever other system, and try to put your concern in another country. No? Yeah.
Absolutely. Thank you very much. I think that you put on the table the main points on what the tribunals should analyze on these aspects to resolve whether there is or not a judicial failure or a denial of justice. Eduardo, are there any preventive or remedial measures that you would recommend to reduce the exposure to treaty claims? And in your view, how could the USMCA dispute settlement mechanisms, or the investor-state dispute settlement be triggered by these judicial developments in Mexico?
Can the vote next June 1st be stopped yet? Of course, that was just as we would say in Spanish, chascarrillo. I think that what measures can be adopted? Well, naturally, ensure that, I mentioned earlier that the government has, the state, the federal state, Mexico has the obligation to ensure the existence of a competent judiciary. So you're going to elect judges, you have to train judges, you have to ensure that they go through a process of competence. Unfortunately, that is probably not what the people who envision this judicial reform desire. I will not go to speculate on what their desires were, but I don't think, it's a personal opinion, that their objective was to ensure competence of a judiciary. Now, the steps that Mexico has taken, not as a consequence of this administration, is to limit, under relevant treaties, claims for denial of justice. Few people focus on the fact that under the USMCA, this is TEMEC, the treaty that replaced NAFTA, the claims for denial of justice are now extremely limited. As probably most of you know, the claims under the treaty are allowed under three categories. One, the legacy claims, which period already expired to bring them. Then the regular claims that can be brought by investors, and a third sector, which is the covered government contract claims under very specific industries, which one can englobe through infrastructure, electricity, oil, certain industries that can be globalized through, saying, infrastructure, and government contracts, and of course, government contracts that deal with the Federal Electricity Commission or the national oil company, Petróleos Mexicanos. It is only under these covered government contracts that a protection for fair and equitable treatment and consequently denial of justice can be argued, not on the rest. Now, we still have dozens of bilateral investment treaties, APRIs in their Spanish acronym, and we also have other trade and investment treaties in place that still grant that protection. Now, the effort on the part of the government will be whether or not to renegotiate all of these other treaties, both the BITs and the trade and investment treaties, to start reducing the scope of that standard of protection. Does Mexico want to afford investors of, and we have a long list of these countries with which Mexico has entered into these treaties, do they want to protect the investments from those investors from those countries to ensure that they are not affected by a denial of justice, as we have attempted to describe today? That is the question. I know that after the party, there's always a hangover, as they say. And yes, there was a party for 20 years in which every country that prided itself in free trade wanted to enter into free trade agreements, into bilateral investment protection treaties, and now they are looking at the consequences. And one of the promoters of the investor protection provisions was the United States, it was Germany, it was many other countries, and now they're realizing that this can backfire, that claim can be brought also against them as states, and therefore they are withdrawing. In the previous group, there was mention made about how there is a movement to restrict ISDS, investor state dispute settlement, and there is. Not only to regulate how the claims are dealt with, as the Mexico-European Union treaty has adopted, although they still keep very close and are not yet made public the terms of the provision, that movement is already in place. So will the movement expand and start to erode all of these bilateral investment protection treaties or not? I think that's where the issue lies. You can argue that the United States and Canada have agreed. Well, naturally, Canada withdrew, as probably most know, from the resolution dispute mechanism under the USMCA, the TEMEC. But does the United States wish to continue with this protection? No. When we renegotiate the treaty starting this year, we can be sure that they will not attempt to expand these provisions. They will either confirm or even reduce the protection. So the question was, how can we attempt to reduce claims on this standard? Well, of course, train your judiciary, ensure that it has competence and avoid mistakes also that some countries have committed. There is a well-known case that was brought by the concessionaire of the airport, one of the airports in Venezuela, case that involved the cancellation of that concession to operate the airport in Venezuela. And if you read the background of that case, there was clearly a lack of justice. Not only a denial, there was complete lack of a judicial structure and judicial proceeding, and ultimately the decision that was issued in that case was unsustainable. And we discussed earlier during this table comments that when you have a judicial decision that cannot be understood or supported and it has no grounds, then you will identify denial of justice. So we have to avoid getting into that situation.
Thank you very much, Eduardo. I think that you have already posed some very interesting questions to reflect in the future about the interpretation, the application of this standard. In fact, you have mentioned the agreement between Mexico and the modernized agreement between Mexico and the European Union, where, as I'm aware, that agreement will replace the whole or the 16 bilateral investment treaties that Mexico has into force, and for a new chapter. And this new chapter have already included a provision with this standard that clarify the scope and the language of this standard. So we should
clarify and reduce.
Yes, reduce reduce the scope of this. So we should see how the arbitrary tribunals will interpret in the near future in light of these new standards. So let's move now to the, thank you very much for your fabulous, extraordinary interventions. Now we move to the questions from the audience. Please, here we have.
Oh, thank you. Jorge Escalona here. Thank you very much for the presentation. I think it was very enlightening to hear your thoughts, especially coming from a specific experience that you've handled these cases. Gabby, you were sharing your experience as well. Well, it's more of a thought and then a question, if I may. I'll try to be brief. For me, the question, it will definitely be one that perhaps it will be included in an investment award in the future when a tribunal might analyze how, if the Mexican judicial reform, and I think it's very valuable how the question is framed, because it's either on the FET, depending if the specific treaty has an autonomous clause, or on the MST, and Dr. Siqueira was explaining that it's the protection under the USMCA. So I think my thought is, one, it seems that this judicial reform might be kind of like the second part of this erosion of cases that when the Lyon decision was issued, it gave kind of leeway from these new cases where denial of justice is being argued against the decision of Mexican courts. So I think now, and former Justice Cosío was doing a distinction that by itself, it might raise the question that it will depend on how it will be implemented and vis-a-vis on how each case and how each foreign investor having a judicial proceeding before Mexican courts might or might not suffer from all these procedural irregularities, delays in receiving judgments. But I think the main question is, and here I present this to you, is how perhaps if there is a future case where an investor raises an argument of denial of justice on their, let's imagine MST, which perhaps it could be a higher threshold, how would the state in an investor arbitration case could then argue that the reform in itself was based on a substantiated public interest protection because, I mean, of course, the speech of former President López Obrador was democratizar el acceso a la justicia, but I think the exercise that the potential tribunal could do on weighting the public interest that was being protected when the judicial reform, with the initiative decree of proposing it, and then all the process that it followed through Congress, and then how it was implemented. I think all this process will be examined by a potential tribunal. So in your view, how would you think a state could perhaps defend that measure through the judicial reform and those changes were lawful, no? Especially with the risk of having politicized risk of not having an independent and impartial judges, no? I think that's the question.
Thank you. We can take 2 more questions, and then, or do you want to answer each? Okay, okay. Gaby, do you want to answer? Or
I think one needs to make a difference between, if I understood correctly, your question is whether in a denial of justice case, a tribunal would actually examine the process through which the judicial reform was implemented. And again, it's guesswork, right? Because we are not there yet. But my take is that a tribunal would rather look first at the facts of the case and how a particular case was conducted rather than the judicial process. Because it's not the judicial process that, or the judicial reform that is needs to be examined, but the facts of the particular case. And let me, maybe it could help an example. If, for instance, the judicial reform would have included a provision that said that from now on, investors would not have access to first instance courts as a premise. And that would just have a very circumscribed right to access to justice. Maybe that could be a basis for examining the reform itself. Another hypothesis that I thought about when preparing this conference is the role of the supervisory body, the new body that was created, and how in practice that body could intervene in specific cases. That could be another, I would say, basis maybe to examine, but more than the judicial reform, the actual practice or how that body actually intervenes. That's my take, and maybe others can have other views.
Thank you, Gaby. Someone wants to make? Okay, let's take one more question, please, because we are running out of time. Okay.
We can take both, but very, very short, 30-second questions.
Just please.
I'll be very short. Do you have any comments on the recent decision in the Finley versus Mexico case? Because I think that's going to be very important for substantial denial of justice. Thank you.
Can you hear me? Taking into consideration the Lion v. Mexico case and this tendency to reduce the scope of the concept of denial of justice, could be possible that this reduction could lead to a lowering of the standards of exhaustion of local remedies in claims regarding denial of justice?
For your questions, who wants to answer?
I'm sorry, can you rephrase the last question? Can you phrase it?
Taking into consideration the reduction of the scope of how these claims regarding denial of justice is happening, could, in compensation, could arbitral tribunals begin to lower the threshold of exhaustion of local remedies, like the situation in Lyon versus Mexico?
Okay, I don't think it would be such as lowering the threshold. The scope of denial of justice may be reduced to certain cases, but exhaustion of local remedies will really depend on the facts of the case and really on the arbitrator's reasoning of the judicial system, of how the administration of justice worked, of how grave or how serious were these errors that could have occurred. If, for example, as in LMC versus Mexico, if there was no other way to redress the wrongdoing. So I don't think it would be, there would be an impact on the threshold, only on the scope of the cases. That's what I believe.
Well, thank you very much, Andrea, and thank you very much to all for attending this panel. That's all. Okay, okay. Gracias a todos. Un aplauso.
So we'll be back at 2:30. We'll make the break for lunch. Thank you.
Good afternoon, everyone. Welcome to this second part of our Mexico Arbitration Days 2025. I'm honored to be joined by a distinguished panel of experts who will bring a diverse perspectives to today's panel. First of all, I would like to introduce our panelists. I have here at my right, María José Guerrero. She is a lawyer and professional in government and public affairs from University of Los Andes. She is a teaching assistant in international economic law and coach of the university team for the John H. Jackson Moot Court competition. María José is currently an associate in Strategy LLP. Here to my left, I have Eleanor Irney. She is a counsel at Hughes, Hoover and Reed in Washington, D.C., where she has practiced both international commercial and investor state arbitration for almost 10 years. She represents both state entities and commercial parties in arbitrations in the energy, mining, aviation, and construction sectors, among others. She's also an adjunct assistant professor at American University's Washington College of Law, where she teaches international commercial arbitration and coaches the school's Wilhelmsburg International Commercial Arbitration Moot Court team. Fernando Mayer, he is the General Director of Foreign Investment at the Ministry of Economy. Previously, he served as General Director of Services and Investment. In that capacity, he was involved in the USMCA negotiations in the areas of digital trade, temporary entry of business persons, and energy. Then I have Carlos Bejar. He is a leading expert in international trade and arbitration with over 25 years of experience in more than 30 international disputes and numerous treaty negotiations on trade and investment. He served in Mexico's Ministry of Economy, where he was part of the core team in WTO and NAFTA and CPTPP litigation and negotiations. He is currently a local partner at White & Case in Mexico City. And last but not least, I have Hugo Romero. He is a partner of RRH Consultores. He is also a professor of international law at the Faculty of Law of this university. He advises clients on international trade law and investment law. He worked at the Ministry of Economy for over 15 years in international trade law and trade and investment disputes. So without further ado, I will pass the floor to María José Guerrero to present our panel of today.
Hello, everyone. Good afternoon. So my name is María José, and I will be giving you a brief presentation, if this moves. Yeah. A brief presentation of the context of the situation and topics that will be further delved into by our panelists. So, it's not working, I'm sorry. Okay. Perfect. So we have a paradigm shift in U.S. trade and investment policy. And this also started with the NAFTA change. And I think we have already discussed this from the beginning of our panelists, but I will just give a brief introduction for the ones that are coming up new here. So a few key legal changes from NAFTA to the USMCA. So the ISDAs was eliminated between the US and Canada, which basically means that no Canadian investor or US investor can initiate a dispute among each other. We had another change on the ISDAs between Mexico and the US. It was not the same as Canada, but it was a limited scope, which means that arbitration can only be initiated in cases such as oil, gas, and other sectors. And finally, we had another change of labor and environmental enforcement strength. There was another important and major thing that changed, that it is the TPP withdrawal. So we know that 12 members initiated this consultation in order to sign an agreement that will further on strained trade in global trade. However, the US withdrew, but the remaining 11 countries did sign this. Why is this so important? Because this had participation of Asia. Countries such as Mexico, Chile, and Peru were participating in this agreement, which they finally did participate, but the US withdrew, and that made a change. So finally, the name of this agreement was the Comprehensive and Progressive Agreement for Trans-Pacific Partnership. Then unilateral trade measures that were implemented by the US. Okay, perfect. So we have a few measures, and I will give you some examples. These are not all, but we have Section 232 and Section 301. The Section 232 was about steel and aluminum. So in this case, it was invoked on March of 2018 under the Trade Expansion Agreement of 1962. Which were the key affected partners in this case? Canada, Mexico, Brazil, and Argentina, which had mainly exporters of this type of products. Then we also had Section 301, that it was invoked on the same year, but on July. And in this case, it was targeted under tariffs from China. This had an indirect effect on supply changes of Mexico and Brazil. And then, okay, I will go, okay. So we have a regional impact. In this case, we have two types of the regional impact. So the one I just discussed about Canada and Mexico facing tariffs, even though that they were a part of the NAFTA, but also WTO disputes arise from this previous tariff, which meant that countries such as Canada, the European Union, and even they were faced again the US. And on 2022, the WTO dispute settlement body decided against the United States, recognizing that there was a violation. However, this was not recognized by the US, which further on strained the idea that they were moving away from multilateral agreements. And the Latin American responses. So this is the final block of the presentation. In this case, we will discuss a few measures and consequences that were faced here in Latin America. So for example, Brazil has now an alternative treaty that does not take into account arbitration when it comes to dispute. Colombia and Ecuador have renegotiated their bids in order to make them more specific with the specific clauses, for example, for cases for the fair and equitable treatment, most favored nation, and other clauses that are now harder for disputes to arise. And then we have an emphasis on state regulatory powers, and regional blocs have come to have more importance nowadays, such as the Mercosur, the Pacific Alliance, and other type of regional blocs that are now very important. Why are they now important? Because they are not being trusted by the countries, such as in Latin America, to make investment arbitration. Which are the practical effects on dispute patterns and investment? There is a decline in ISDA's claims by US investors because, of course, with the change of the USMCA, this has lowered and has a deep impact, but it is because partly due to the reduced access of the USMCA. There is also a big shift to contractual arbitration, which means that now the parties are now relying on their contract-based clauses, that it is dangerous in the case that there is not it is not specific enough as a treaty, that we usually have these clauses more sorted out. And finally, there is a focus on legal certainty and enforcement because now the countries are looking for legal stability within their investment. And new trends in intra-regional dispute have arisen. So we now see more investment between Latin American countries within each other. And with that being said, I think that now we have a little bit of context of the decisions made by the US and now how Latin America has responded in some way. So I will now yield the floor to Samantha. Thank you.
Thank you, Maria Jose, for giving us this broad perspective of the topics we are going to be addressing with our panelists. Certainly, some of the measures that you just mentioned were taken during President Trump's first administration. And now, since he took office last January, we are seeing a wide range of measures in different areas, including trade and investment. Not only this increase of the use of Section 232, Section 301, but also another law came into play, which is AIPA, which is being used by the president to impose tariffs. So traders and investors around the globe are facing a climate of legal uncertainty that pervades their business relationships. It is difficult to predict the course of the rest of Trump's administration, but many agree that this uncertainty will remain. So I would like to start with Carlos. Is the United States approaching a turning point in the region that will undermine trade and investment? And is it possible that the United States can come back from that turning point?
Thank you, Samantha, and nice being here with you all. Thank you for the invitation to Ricardo Ramírez, RH Consultores, to the Instituto de Investigaciones Jurídicas. Carlos, I don't see him around, but thank you very much for having me in this panel. And with regard to this question, the first thing that I noticed that it's not a question that we drafted, but I'll try to address it as I see fit. The first thing, I guess, is this affecting investment? I think it is clearly affecting investment, at least in Mexico. I mean, from my perspective and the information I've gotten from deals that we were working at is that many of them just got freezed. They just are waiting to see how water settled down and whether to continue with the projects, whether to enlarge their capacity in Mexico or no. So it has an effect of chilling the investments in the region. On the counterpart, the question is whether this is actually increasing investments in the US, which apparently it is, and that's actually what I understand to be the main objective of many of these measures, or one of the underlying objectives of the measures adopted by the US, because most of them are related with tariffs, and they don't hit or they don't cause the same effect on all industries. So the problem with these measures is that they are very uncertain as to the effects because it depends on each industry, on each country. So it's very hard to say that this increase of tariffs will have the same effect in all industries, with all companies, and in all countries. So I think that's why until this is not clear, people will not be taking important decisions, I guess, although there has been already important announcements of moving or increasing investments in the US, particularly in the automotive sector, which is one of the main, characters or main industries that are of interest, particularly to countries like Mexico. The other side of these measures is that it has been so fast, there has been so many things in such a short period of time that it is very difficult to come to any conclusions with regard to what has happened and what will happen. And there are many ongoing investigations as well, as you mentioned, with under the authority of the US president. The question is also whether the US president has actually the authority to do many of the things he has done. And to challenge this is not something easy. It has to be done mainly it's obviously trying to be done in the WTO, but we know where the WTO stands. So there are not that many other international forums where these policies can be challenged. And the other ones are local courts. And I understand that this takes a lot of time as well. It's not something that is clear-cut with regard to this authority. And there are, I understand a couple of cases that have been already started to challenge this authority, but it will take time to see what happens with this. And by the time these results come, these decisions may have already taken consequences. So my last point, for not taking more time, is should we look at this as a 4-year uncertainty in terms of will the new administration after Trump leaves the presidency will the U.S. continue with these policies, or will there be a shift back to where we were before he started adopting these decisions? I think they will continue in a way. I think the U.S. has been, in certain aspects, meeting this or pursuing the same objectives. It's just probably how they are doing it, what is different. And I think that at this time, it was, as I said, too quick. Probably a little bit too aggressive for some countries, and we are still reacting to those measures. So there is still much story to tell.
Thank you, Carlos. I would like to take advantage of the presence of Fernando to also ask for his point of view on this question, but I will also pose another questions to Fernando that is kind of linked to this climate of uncertainty that we are dealing with. So a couple of years ago, Mexico displaced China as the top trading partner of the United States, achieving a greater share of the U.S. trading goods within the world. In 2024, it still was. So these actions not only impact trade, but also investment. How is Mexico facing these actions? What has this meant in terms of investment growth in Mexico? Could you also provide a quick overview of Mexico's investment outlook?
Thank you. Thank you, Samantha, and also really happy to be here with you. Thank you, Ricardo, RH, for the invitation. Thank you, Hugo, also, and happy to be with Maria and Eleanor. Good afternoon to everyone. And well, I have a presentation that actually, I don't know if we can put it, and I promised Samantha that she's really worried about my presentation because it's really long. But I promised her it will be really quick. So yeah, I saw it. Don't worry, Samantha, it's only going to take 5 minutes. Yeah, it's long, and I'm happy to share this presentation, obviously, with all of you. And well, as I say, thank you for the invitation. I am right now in the office as General Director of Foreign Direct Investment in the Ministry of Economy, coming in representation of my boss, Ismael Ortiz, the Chief of Unit, and Undersecretary Luis Rosendo. Right now, Undersecretary is in Mexico, is not in Washington, but maybe tomorrow will be in Washington, because as you can imagine, he's traveling a lot for all these tariffs issue that Carlos, you explained. And just in this part, and really quick before entering to the presentation, speaking about really quick the government perspective and Trump administration, I agree completely with Carlos when he said that it's too soon to know what is going to happen, but at least we have a plan in the Mexican administration. And this plan is to continue growing the relationship with the United States and Canada. Canada and the United States are our biggest, obviously, partners, and we want to continue this integration, taking into account that right now with Trump, it's really complex, this part. And also, we have the issue that we are receiving and also seen as really important player with other countries, obviously including China. If we see the information that we have of the general direction, we can see that China is not part yet of our 10 top investors country in Mexico investments. He is right now in 14th place. And actually with this new data that we are just about to issue today or tomorrow of the first quarter of 2025, China, it's almost the 18th country in Mexico for investment, not trade, investment, right? So this thing that we are hearing that China is the backdoor for Mexico is not true, at least in the numbers, because you need to make difference between the investment that it's already in Mexico and the announcements that the companies does, both well, in this part of China. But obviously with Trump, we are struggling to see what will need next steps. At this moment, we can see Mexico is not in the best situation, obviously, but it's in a better situation than other countries. We have tariffs applying only to some sectors, like obvious aluminum and steel. We have to see the rule of origin and the auto parts sector to see the tariff that would apply to the auto parts sector, and to see if the auto company will pay the 25% or will pay less. We are in that negotiation at this moment. also trying to take out the tariff for steel and aluminum. And if, as you know, if we accomplish with USMCA rules of origin, Mexico will still have for 0% USMCA products. So it's not the best scenario, obviously, but at least we are better than other countries, and we are trying to work with this to integrate more with the United States during these 4 years of Trump administration. So really quick, the presentation I have to you, it's a really quick overview about the Mexican landscape and the things that we do in our office. I will not stop really quick in this information. As you know, all this information about macroeconomic statistics in Mexico. Little bit what we want to achieve with Plan Mexico, you will see in a moment. And the good, obviously, I came from the government, I need to have good news for you. But we are seeing some macroeconomics information and statistics that are really good for Mexico at this moment. Also information that you can find in the IMF. We have our trade agreements that it's still in place. Part of also of the Mexican strategy is to have a revision of the USMCA agreement. We are not in this moment willing to enter into a renegotiation as we do in 2017, 2018, but obviously we will need to see what will be Trump's approach to this and just here to this issue. But at this moment, we are preparing to have a revision, and if it's a renegotiation, also we are ready for that part. A little bit what we want for Mexico in 2030 to be one of the 10 most important economies in Mexico, in the world. It is complicated, obviously. It not only depends on our free trade agreements, it's also depending on infrastructure, local regulations, etc. So it's a lot of job to be done, but President Claudia Sheinbaum is trying to put this in Plan Mexico, also a really important economic export in the world. How we are, that is why the integration is so important. Our exportation web, you can see there, it's really similar, United States, Canada, and Mexico. I mean, this information, we will have it, it's just going really quick to see a little bit more numbers of foreign direct investment. Also, the investment that we have in the public sector, in the private sector, and how this is really important for Plan Mexico and to achieve President Claudia Sheinbaum really the goals, ambitious goals she put in Plan Mexico. This center to my office, this is the last numbers that we have of foreign direct investment in Mexico also, and obviously people like Carlos are really more in touch with foreign investors in Mexico than we are. We are trying to receive investors in my office and try to help them in the soft landing or if they have new investment projects in Mexico. But it's for sure that a lot of companies are still in a standby process right now to see what will be the reaction to Trump. And also, and we need to say this, the reaction to issues that are also happening inside Mexico. Our only problem is not Trump. We have internal issues that we need to see and to solve. The Minister of Economy is working with this dependency to do that, but also we need to address these issues internally in order to be and continue being an interest country for foreign direct investment. But this is the number. You can see that for the last part of last year, we grew 2% compared to 2023, and this is good news at least because if you see UNCTAD information, the foreign direct investment in other countries decreased 8%. So Mexico is still having a good moment in investment, and I cannot give the information of this quarter because I think tomorrow President Sheinbaum will say it, or my boss, Secretary Brad, and I will get really spoiled exactly. And as you know, in political, that is a more important thing. But we are going to have good information, at least from my perspective. I know a lot of people will say, hey, new investments, reinvestment, etc., right? But at least we are going to have a number, a good number. And this is already the reality that we are seeing from Trump. Let's see the second quarter in Mexico, but this first quarter, it's going to be something at least manageable for us. Going on, this is more information about the last information that we have in my office. My office is in charge of the National Commission of Foreign Direct Investment, la Comisión Nacional de Inversión Extranjera. Is also in charge of the RENIET, that we have this information, the National Register of Foreign Investment, Registro Nacional de Inversión Extranjera. That is a really important number, that is actually the only macroeconomic number that the Minister of Economy issue, and this is this foreign direct investment number, that it's also part of the central bank and information the central bank will give on Friday. Our top investment countries in 2024, US, Japan, Germany, Canada, Netherlands. this quarter we will change to Spain, for example, to France, because it depends what the companies report to us and the nationality of the investment. It's really moving this part. Also, this is a part of the states. This in my office, we're working really hard in this part because to see Mexico City there is not accurate. I mean, and the numbers say it, but it's because the RFC, the number of the company, the legal number of the company, it's registered in the city, but it's not registered where the investment actually is happening. So we are trying to move this number and trying to help the states as Mexico State, Baja California, etc., Nuevo León, so the companies actually register the foreign direct investment in their states and not in Mexico City. And Mexico City agree with this part because we need to have a good number in order to know the reality. This is about the public investment announcement. It's really quick just to say that we don't need to mix the information. One thing is the Registro Nacional de Inversiones, and the thing that we have in the register, and another thing is the announcements. The announcement is more a political issue. It's the things that you see in the Mañanera with Presidenta Sheinbaum saying a lot of money to invest, but it's only announcement, and our job in the office is to solve this investment into actually real investment, right? More general information about public investment announcements, the states that we have the most important announcement right now, and if you need to check this information, we have a really important, good page with Ismael, that is Data Mexico. Happy to check that part. I will pass this really quick, just to, in another a chat that we can have, we can go more deeply in Plan Mexico, but also we are applying Plan Mexico in the general direction of foreign direct investment, trying to help and to get to the number that Presidenta Sheinbaum wants to have on 2030, and the goals that she put over there. That is a really ambitious goal, but we need to work in order to get to those goals. In general, the private sector have welcomed really good the Plan Mexico, but obviously we are in a part that we still in the clouds, and we need to go down with Plan Mexico, obviously. Information from Plan Mexico. This is really important, and I will almost finish my presentation. Samantha, don't worry, is the tools that we have in my office to help foreign direct investments. The instruction that we have right now from Secretary Brad is to help soft landing to foreign direct investments, taking into account all the complex issues that we have in other countries and in Mexico. So we have La Ventanilla Única de Inversiones, the only single window of investors, and the RUPI, Registro Único de Proyectos de Inversión, a single register of projects of investment. The Ventanilla, it's an information platform that you can check any moment you want. It's all information about states, micrositios, sites that you will have information for regulations in specific Mexico states. But the register is really important. It's for company that wants to apply. It's not obligations. It's a company from my office, and Paulina and Leonor is part of this office that have these projects, is to accompany hand-by-hand companies, that foreign direct companies that want to have new investment projects in Mexico, above $100 million. So we help them in order to have permits, in order to have tables, and to speak with other dependencies. We are like the middle people to help the companies with the relationship with other federal dependencies. And the last part, well, the announcement of investment, and the last part, the national register that I just speak about, National Register for Investment, is this information that we spoke at the beginning. And hopefully tomorrow you will see the new number of 2025. And yeah, that's it. Really quick about a quick overview of the foreign direct investment in the office. And thank you, Samantha.
Thank you, Fernando. You really spoke really fast. I hope our audience can digest all these numbers, but as you mentioned, you will be sharing these interesting presentations on how investment is growing in Mexico. And you know that when investing, investors also seek legal certainty in the countries where they are investing. Of course, investors in the North America region have a long-standing relationship. Some of the investments in the region are really integrated. So I would like to seek Eleanor and Carlos' view on what is the impact for investors and their investments in Mexico and in the United States. Can we expect challenges under the investor-state dispute settlement mechanism arising, for example, from these tariff regimes imposed by the Trump administration? And what does these claims may look like?
Thank you, and thank you to the organizers for inviting me here as well. I am happy to address this from a U.S. perspective, although I will begin by saying it is, of course, very complicated. So in terms of what these sort of claims might look like, taking the last question first, I think there are a few sort of, I'll call them obvious examples of substantive protections that exist in treaties, bilateral, multilateral investment treaties, as well as in trade promotion agreements that could in theory apply to these tariff regimes. The first is, of course, the substantive protections against discriminatory conduct that come in the form of national treatment obligations and most favored nation treatment obligations. The second are violations of fair and equitable treatment, particularly where that pertains to the obligation to not treat investors in a way that is arbitrary or to subject them to unreasonable government conduct. And the third, and I pull this one from prior investment treaty claims involving tax regimes, which are implemented somewhat similarly to tariffs, is the substantive protection against expropriation and measures tantamount to expropriation, so long as those measures are undertaken, discriminatorily, without public purpose and without adequate compensation or due process to the investor. So I do think that there are certain treaty regimes that could, in theory, apply. But with those in mind, I think there are also a couple of significant hurdles that an investor might face in trying to bring one of these claims. The first is really how to frame the investment itself. And this is because the nature of tariffs is such that they affect imported products on a domestic market and on a sort of sector basis within the economy. And so to be subject to treaty protections, investors have to be able to show that they have an investment in the territory of the country that enacted the tariff, that they are an investor in that country as well, and that the tariff is affecting them in that particular host state market. It can't simply be an effect on the company where it exists at home. And the reality is, I think that many investors that are subject to the current tariff regimes on the import of their goods don't have significant operations in the country in which they are importing the goods to. That is not always the case. Obviously, there are certain investors in the United States in particular, in the solar industry, that have an investment in the United States that depends significantly on imports from their home country. But I think that that's the sort of outlier case at the moment. I've been sort of trying to conduct a brief survey myself about this. And I think this is particularly true, this particular shortcoming or difficulty, in the case of the agricultural tariffs that form a lot of the retaliatory tariffs announced against the United States. And this is because, obviously, in the case of agriculture, it is domestically produced and then shipped abroad. And so the particular investment that an investor might be trying to protect in the agricultural sector abroad is really a portion of a supply chain. And it's difficult and very much depends on the language of the treaty that applies, whether that can, in fact, qualify as an investment. The second potential hurdle relates to the justification for tariffs, and this is because while the potential treaty claims that I mentioned seem facially applicable, the stated justification for these tariffs, and I take no position on the right or wrongness of that stated justification, and even the retaliatory tariffs, is frequently protection of domestic industry, which could constitute, in theory, a valid public purpose for enacting the measures. And in that sense, I note that the US-Mexico-Canada agreement that we've talked about does include provisions in its articles on national treatment and most favored nation treatment alike that state that whether the foreign investor bringing the claim is deemed to be in like circumstance, which is required for bringing one of these claims, must be in like circumstance with a domestic company, depends on whether the treatment at issue distinguishes between investors and investments, and here I'm quoting, on the basis of legitimate public welfare objectives. And as Maria Jose explained, the administration of President Trump has invoked, through its use of Section 232 and Section 301, both domestic protections and national security in enacting the tariffs that it has put forward. And of course, another key feature of the USMCA is the limitation on ISDS claims. And so with respect to Mexico, the claims are limited between Mexico and the United States to national treatment, most favored nation treatment, and direct expropriation. An example of this potentially comes in the case of Vento Motorcycles v. Mexico, which was a NAFTA case several years ago. The claimant was a US company that brought claims under NAFTA, alleging that Mexico had denied it the benefit of preferential import tariffs, in that case duty-free regimes, that it said impacted its sales in Mexico. The claimant did not contest the findings of Mexican authorities that they were not of US origin, the particular imported motorcycles, But they did allege that the review was undertaken at the behest of the incumbent motorcycle industry leaders and the Automotive Industry Association. So I'll note that first, the tribunal there did find that there was an investment in Mexico in the form of an enterprise created by joint venture, but it found that the claim that Mexico had exercised its authority at the behest of local industry was not supported by evidence, and that was a very strong finding in the award, and did not constitute arbitrary or discriminatory treatment. And so that it sort of illustrates how these hurdles might arise in cases involving tariffs. I think one other issue really relates specifically to the United States, which is simply that in the context of claims either against the US government or by US investors against foreign governments, there aren't very many investment treaties to which the United States is a party. And the tariffs include tariffs against China, Vietnam, Japan, Indonesia, India, and the European Union, with none of which the US has a current investment treaty. And thus, in many cases, there may not be a treaty to rely on. But with all of those things in mind, I'll conclude with just a few statistics on foreign direct investment in the United States, in part an answer to what Fernando told us about Mexico. I don't have the most up-to-date data because I only have what's publicly available. But according to data reported by the US Department of Commerce, as of October 2024, the majority of foreign direct investment in the United States was in the manufacturing sector. And greenfield investment, which is defined as establishing or expanding on a foreign-owned business in the United States, totaled $8.1 billion in 2022, of which $5.3 billion was dedicated to the manufacturing sector. And as of 2021, the ultimate beneficial owners of most majority-owned US affiliates of foreign multinational enterprises were found in Europe first, followed by Japan, and then by Canada. Thank you.
Eleanor, Carlos?
Have much to add. I think it's case by case at the end, but I see it very difficult to propose that tariff increases in themselves are in violation of investment standards. And the other question would be that, or the other issue I think is that after the USMCA, as was mentioned in the previous panel, the availability to challenge for discriminatory measures or, I mean, you can only file generally for discrimination or for expropriation. Mm-hmm. So there will be limits for all of those related with the minimum standard of treatment. And that's also an issue here because normally most of the investment cases relate with the minimum standard of treatment. So the chances of being of receiving cases under an investment treaty, I think, are extremely low, unless you can find probably a decision, and this is probably something to think about, where Mexico would like to react to counter the effects adopted or caused by these tariffs by providing assistance to specific companies or creating some sort of discrimination between local investors that put them in an advantageous position before others. So I think that, as I said, it has to be analyzed on a case by case, but I think it's important to follow up on what Mexico could be doing because it's not much about what we can, what Mexican investors could do in the U.S. because Mexico also doesn't have that many investments in the U.S. and like you mentioned this case, and there was also the Cargill case, which Mexico argued before the Canadian courts against this case because Mexico was forced to pay one of the investors because of the investment they had in the U.S., but was extremely linked with the investment in Mexico. So and Mexico argued, this is trade, this is not investment, so we are not going to pay for damages caused to your trade. And I think this was in some sort of way incorporated in the USMCA in the definition of investment or what is not investment. Mm-hmm. And I think it says something about commercial contracts for the sale of goods or services. So you will first have to pass that hurdle of, okay, you are an investor. And the question here is, you're probably not because those contracts are, or those violations are related with commercial contracts. So it will be difficult to bring a case, I think, against these measures.
Thank you, Carlos. Hugo, would you like to comment also on this question?
Yeah, thank you, Samantha. Just a brief reaction on this. if Mexico or other country takes countermeasures regarding the tariffs of the United States, then we will have a deja vu in the fructose cases. Do you remember ADM in 2007, I think, where the panel discussed the nature of the substantive and procedural rights, and it determined that the substantive rights were between the states, but the procedural right, it means the right of the investor to initiate a case against Mexico was a self-contained regime, which implied that Mexico, maybe you remember in the fructose cases, Mexico imposed a tax on certain goods as a countermeasure reacting to the opposition of the United States to accept imports of sugar of Mexico. But the ADM case said, well, the procedural right that has investor is different. So, and this could be theoretically, at least, we can see this from US investors affected by countermeasures or retaliatory measures, or non-US investors in Mexico. Particularly, and it would depend on the nature of the countermeasures. If it's tariffs, I mean, just reacting, increasing the tariffs, the hurdles that Eleanor mentioned will be also applicable here. But what happens if Mexico decides, as Ecuador at some point, when try to retaliate against the EU in the case on bananas? Ecuador said, it's not feasible to retaliate on goods. I will affect intellectual property rights. So then investors will be affected, and possibly they could initiate a case. I think that's another part of these tariff measures and retaliatory measures. Mexico has been very cautious in taking measures, but potentially we can see that. And finally, this morning, one of the speakers here mentioned the national security clause. If Mexico is taking countermeasures, could say this is to defend my national security. And in certain VITs, it has a special clause, like I take the VIT Mexico-Switzerland, that says dispute settlement does not apply when there is a national security issue, as in the recent case Angel Seda and others against Colombia. So, thank you.
Thank you, Hugo, and I will stay with you because you are touching the point of how to challenge these measures. The imposition of tariffs under these U.S. domestic laws appear to be inconsistent with international trade agreements. Few countries, and I think Maria Hussein in her presentation already talked about some of the WTO disputes. Some countries like Canada and China have challenged these measures under international dispute settlement mechanisms, while others, and you already mentioned the Mexican position, have taken a more conservative stance. So is there, in your view, a general discouragement in the use of this mechanism, and what could be the reasons for that?
Thank you, Samantha. And I think we are facing a crisis of the rule of law. Basically, a president is imposing tariffs, and there is no remedy, or not quick remedy. Another country is taking countermeasures, and it's exactly the same. And since December 2019, when the appellate body was not functioning anymore, for good or for bad, I don't know. But after that, simply the number of cases initiated under the WTO have been decreased a lot. Others, like myself, say, okay, well, now that the WTO is not functioning very well, maybe we can see more cases under the regional trade agreements. In the case of the USMCA, it happened, but still the numbers are very, very, very low. Mainly because I think that now this is the crisis of the rule of law, or we are in a transition period where after the end of the Uruguay round and the establishment of the WTO in 1995, we saw many cases. The jewel of the crown was a dispute settlement system, and within that jewel was the appellate body. But since, as I mentioned, since some years, well, we haven't seen any intention of the Biden administration to make it functional. And during the Trump first and second administration, in the second, I'm not sure what will happen. But currently, just trying to initiate a case maybe is a waste of time, precisely because the nature of I wouldn't say the nature, but the imposition of tariffs have changed right now. I don't know whether in the last 40 minutes that we started, there is a new post in the Truth Social, but I think is this the idea of the crisis of the rule of law? Or maybe we are in a transitional period where after the success of multilateralism, countries are changing policies and they will build a new system. I don't know when it will end, but I think the uncertainty of the tariffs is what is most discouraging the trade. Paul Krugman say, well, if anyone knows that in the following 4 years there will be a 25% of tariffs, well, you make the adjustments. But now, you don't know. You don't know if now it's 25 and it goes to 100%, but they are reduced and exception is made. So I will stop here, but I see a very difficult time for lawyers that are lobbying dispute settlement rules. But, well, maybe we are very traditional, orthodox, and we are not adapting to the new reality. And the new reality is presidents are taking more policy space. Thank you.
Thank you, Hugo. And I would like to seek also Eleanor's point of view from the U.S. perspective.
Thank you. I'll offer just two very brief comments on this. First is that, as I mentioned before, there are so few multilateral or bilateral investment agreements to which the U.S. is a party. The WTO remains one of the primary bodies in which U.S. policies can be brought to bear. And so with respect to both Canada and China, which have requested consultations with the U.S. about the tariffs, the U.S. did respond in both cases. It accepted consultations, but it did so with notwithstanding the official U.S. stance that the tariffs that formed the subject of the consultations are a matter of national security. And going back to national security carve-outs, the WTO has one. And so the U.S. maintains that it is not susceptible to review or capable of resolution by WTO dispute settlement. So it's sort of an interesting question whether you take the only option available to you to request these consultations and see what happens with it, or if you take the stance that it's not going to work, and so you have to do what you have to do. The second very brief comment to I think the sort of last point that Hugo made, in January of this year, the government of Panama filed a request, an appeal from a panel decision involving imports from Costa Rica, which noted that, this is in the body of the request, as there are no appellate body members to compose a division to hear Panama's appeal at this time, Panama awaits further instructions from the division once composed on any further steps to be taken by Panama in this appeal. And so I think there is a sort of a request from the international community to figure out how we can get these mechanisms working again.
Thank you, Eleanor. We are in the time where Trump has reached its 100-day mark at the end of April. And in that time, I'm referring to first and second administration, he withdrew the United States from several UN accords and the TPP, among other agreements. So how have the major trading partners of the US and other countries in Latin America reacted to this economic nationalism? And I would like to seek the views of Carlos on this issue.
I think the main question for many is whether this is actually good for the US or this is actually against its own policies, because some countries are feeling left like thrown into China's arms or closer to China. So if you have a trade relationship with the US and suddenly they raise you tariffs and they put you in a difficult economic situation or position, and you have China offering you better conditions, it is difficult for these countries to decide whether to keep working with the US or whether to move more towards China. So I think that's what I say. This would counter the logical reasonableness of the measures adopted by the US. But I think this is an adjustment period. I think countries are taking sides, which is something interesting. I believe that at least Mexico has, from my perspective, chosen 100% US team. And the investment figures, obviously China is trying to get to many of these other countries to get some of their products that cannot access the US, or at least in theory, that's what's happening, trying to get some of those inputs in these other countries to be transformed or to comply with the rules of origin and then sent to the US. So I believe that the US will still have to address that issue. It's not regulated per se bilaterally. So we may see more future changes in terms of how we relate with the US in our rules of origin and what will happen with this foreign content. They are already in the auto industry, they have clearly sent signals that they will move trying to get rid of these non-US or regional inputs or tariff that part that is not from the region. So these are new formulas that we are seeing now, and that is something that will be interesting to keep an eye on. But Mexico, as I said, the reaction for Mexico has been not to adopt any retaliation measure against the US. So this is what other countries have chosen to do as well. And many are negotiating now with the US on better conditions. Mexico has done pretty well. Canada and the EU and obviously China adopted a more aggressive reaction or mirroring the US decisions in a way. But the EU and Canada were contained because of these obvious flexibilities that were announced by the US and granted. So we can see that things are falling now back again where they were at the beginning. So the US is making clear that they have these objectives, that they want partners to comply with the regulations, and probably this sends me back to the origin of the CPTPP or the TPP. I understood the TPP to be a treaty where the US or the countries that were participating in that treaty were going to agree on higher standards of international trade compliance that will leave countries out of that group in a non-compliant situation, so they could not sell or put their products into those markets because they will not be compliant with those high standards. But when the US decided to move out of the CPTPP, it really created a question of, well, then what is the actions that the US will take or will adopt after this? And what we saw is, well, I'm going to take unilateral decisions. I'm not going to take any more negotiated decisions with anybody. I'm going to impose my own understanding of the regulations, obviously invoking national security, which I should say that it is interesting to see where they come from with this national security. At that time, we had COVID. At that time, we have the Suez Canal blockage. We had the microprocessors crisis. We had the tensions between Ukraine and Russia. So there were many events taking place that if you look at them from a trade perspective, it shows that many countries were vulnerable to these events that were taking place in the world. So they realized if we need, for example, and this is my understanding, I don't know, if we need to produce ventilators to address an emergency, a health emergency on a biological war, and we don't have the inputs to do it here, so we will lose that war. If we don't have the microprocessors and we need to face counterattacks on piracy, or how to say, technological warfare, I don't know, you don't have the input. So there were many things that if you put yourself in a defensive position, you see that many of us are still very vulnerable because of this globalization. Having said that, I don't think globalization is going to be finished. I think everyone that can take advantage of globalization will do better than those that are going to close themselves into as a closed economy. But I think that what we'll see is clear sides on who is making trade deals with who.
Thank you, Carlos. And I would also like to seek Eleanor's views on this question. Thank you, Eleanor.
I'll be very, very brief. I think the first point I'd make on this is obviously that as the CPTPP example shows, these multilateral agreements move on without the United States. And I think it was perhaps a surprise to some members of the US government that did occur. But the CPTPP is now also growing with China, Taiwan, and the United Kingdom seeking to accede to it as of 2021. And the second thing I'll note is simply that within the United States, this does remain an ongoing conversation. And I think I'll give the example of the Paris Agreement on climate change. In President Trump's first term, he did withdraw the United States from the Paris Agreement. That was effective November of 2020. 4 months later, when President Biden took office, he brought the United States back into the agreement. And then on the day of his inauguration, President Trump, on January 20th of this year, signed an executive order ordering the United States to once again withdraw from the Paris Agreement. So I think this serves to highlight some of the tension between the American first policy on the one hand and global commitments. And I'll note that, including those of environmental groups and individual US states. And one example is California, which is a huge producer of solar energy and which signed in 2017 the We Are Still In letter that committed to maintaining the obligations of the Paris Agreement, notwithstanding the US withdrawal.
Thank you, Eleanor. Fernando?
Thank you, Samantha, and also really brief on this part of how some countries are preparing and are facing this Trump crisis or this issue from China, etc. A little bit of perspective of Mexico and the Ministry of Economy particularly, and really agree what Carlos just said about the local inputs and how you need to be prepared on this part. And actually, this is a core issue of Plan Mexico of Presidenta Sheinbaum. And this is before we have Trump's elected, we have the view in this government to have this issue of national proveeduría, national, what do you say? Supply chain, exactly, yeah. And it's not good to get confused about changing from substitution of imports. This program that we have in the 60s, 70s is not the same thing. We are looking here to help foreign, if it's the case, foreign investors to come to Mexico and to produce things that we are not producing at this moment. This is happening a lot in the auto sector, for example, Tier 1 and Tier 2. We have a lot of meetings with all these kind of companies trying to say, hey, come to Mexico at that moment, and let's try to make this supply chain internally in Mexico. It's not easy. It's not something that is going to happen in a short term, and also you need to make also this question that we have this uncertainty on Trump tariffs. Nevertheless, we're trying to go with these companies, and at this moment it's, okay, let's see a North America supply chain. So if they are moving a little bit of this production also to US or to Canada, it's not bad seen at the Mexican government at this point. So we're trying to move on this direction and trying to help new supply chain in Mexico, new also Mexican providers, so they can provide to these big industries that we have in Mexico, and then account with this Plan Mexico in order to achieve this.
Thank you, Fernando. And now that you are mentioning this North American supply chain, obviously considering this US administration position towards China, Canada and Mexico it is difficult for Canada and Mexico just to remain passive. So obviously this tension have a disruptive effect in trade and investment, and we have seen that the United States has implemented measures on outbound and inbound investment. Is Mexico considering similar actions or taking steps to monitor Chinese investment coming to the country?
Thank you, Samantha. I don't know if Lauren helped you with this question, but no, yeah,
From
thank
the
you.
US point of view.
No, yes, I think it's understandable. At this moment, US have a mechanism, it's CFIUS. Canada have also a mechanism. A mechanism is the Investment Canada Act, and also the European countries have a mechanism in order to make traceability on issues regarding national security on foreign direct investment. So I will not target a specific this mechanism to China, because we have seen, for example, the United States also targeting other countries' investment, Japan investments on steel, maybe Turkish investment, things like this. But yes, we have speak with the US and Mexico. It's right now revising if it's necessary for Mexico to have this kind of screening mechanism, right? It's not only to apply to China, it's going to apply to any foreign direct investment coming to Mexico. So we need to be careful not to make this a new border, a new stone for foreigners in Mexico, because we don't want to do that. We want to help them, and we want to establish in Mexico. So if they have the judicial reform, if they have Trump, if they have another issues they need to deal with, and now we are going to put a new issue and revise all the investment that we enter on national security basis, it will be complex. We are revising. If we are going to apply this, we want to do it as general as possible, not mandatory, and trying to be in a middle way that is similar from when CFI started, not being that harsh. But at this point, we don't have any decision yet taken. We are just analyzing and studying the cases that we have on other countries.
Thank you, Fernando. And what is the impact of these measures on investment from your perspective?
Well, I think that after tariffs, the next phase of U.S. measures is looking at where China is investing, what those facilities are producing. In September last year, Catherine Tai mentioned that they were working on a supply chain resilience policy, basically based on 4 elements: transparency, diversity and diversification, security, and sustainability. And based on that, the United States will take a new policy, which, by the way, is open to public comments until June 4th. I think the result of that will be very, very important, particularly in countries like Mexico. Fernando mentioned that is not in the top 15 of China is not in the top 15 as a FDI source, but the announcements is the second. So BYD, for example, mentioned that they are planning to, in last November, they are planning to have a facility to produce cars, and they are saying, we are not planning to send cars to the United States. Yes, but still it's a concern, because if Mexico is consuming BYD cars and they are only exporting cars to the United States, to a certain way is affecting the United States. But I will stop here. Thank you.
Thank you, Hugo. We are reaching the end of our panel, but I would like to take at least one question from the audience. If anyone has a question, please feel free to raise her hand.
Thank you very much to the panelists for this formidable presentation, and thank you for taking my question. So my question will be, to what extent can Mexico leverage the nearshoring phenomenon to achieve truly equitable and sustainable economic development across all regions of Mexico beyond immediate beneficiaries and within the context of the current economic ongoing happens. Thank you.
Who wants to take this one? Or everybody?
That what the main program in Mexico that has supported our export is manufacturing, and it's the IMEX program. So I think that there is supposedly to be announced or published a renewed version of the IMEX in the next month or next couple of months. It has been delayed. But unfortunately, before that, what we've seen is that the Ministry of Treasury, the Secretaría de Hacienda, has been looking at trade as a source of incomes. So they are very active into seeking who is complying or not with the rules, but not with the objective of putting them into compliance, but to actually collect money from them. So if they continue pursuing that with that mindset, I think it will inhibit the investment. It will make investors think about really, some of them actually moving out of Mexico. And for example, there were just recently some exemptions granted to the import of textiles for certain companies that were exporting, and not all of the companies received these exemptions. So the companies that didn't receive these exemptions are extremely concerned because they will have to fire thousands of people and probably close businesses in Mexico. I know that Ministry of Economy has been dealing with this, and they're trying to obviously avoid abuses of the program. But in response to your question, I think the main change or the policies that should be sought is how to foster the existing programs, how to make them a success, to increase investment and to increase our exports into the U.S. And like you said, probably not only in the north of Mexico, but also try to move production to other states of the Republic, which is something that is being sought with creating more infrastructure, having more access to cheapest energy, water. So there are many other concerns that inhibit investment sometimes because you need these type of investments to create to have more investment.
Thank you, Carlos. Anyone? Well, I would like to thank our panelists for your insightful contributions, and thank you to our audience for joining us in this important conversation. It is clear that the Trump effect will continue to influence economic decisions, policy debates, and even geopolitical alignments in the years to come. We hope that today's discussion has provoked some thoughts on this issue, and thank you again. I'd like to invite you to stay for our last panel of the day.
Back home, Todd?
Sorry, I just heard back home, Todd. Can I be heard?
We hear you, Todd.
Okay.
You hear us?
Yes, I do now.
Okay.
Yes, I'm back home.
Okay. And you're flying to Mexico at all or not?
No. I the other stuff I could do, I didn't need to do there, so I can just do it another time.
Okay.
It was very odd though. I've looked up on the news to see if I could see anything about it, but I haven't. Other than there's some talk about some solar flare activity, but nothing about how much it affected a particular type of airplane, which was just odd. But anyway, I believe the Air Canada people.
Or is the airline or the nationality of the airline?
Now, it was apparently all the 737s in the Air Canada fleet were disabled. I did see that the flight finally did leave. It should be landing probably in about an hour.
Oh, well.
Okay, so welcome again. Thank you so much for your patience. We're almost there. This is our last panel, but it is a really important one. So first of all, I want to thank all my colleagues in the table. Of course, Ricardo Ramírez, Edmund Sim, Edna Ramírez, and Todd Weiler. Todd, we really miss you here.
I really miss being there because it's kind of cold and rainy today.
Well, it's good to have you, at least by Zoom. All right, so our panel today is about the rule of law crisis and the use of state-state dispute resolution mechanisms and arbitration in international trade and WTO law. I'm gonna start by addressing some main points and ideas, and then I pass the microphone to the moderator, which is gonna be Edna here. So welcome to today's discussion on one of the most pressing and complex challenges facing the international legal order, the growing crisis of the rule of law in global trade governance and the evolving role of state-state dispute resolution mechanisms, particularly in the context of WTO and investment treaty-based arbitration. At its core, the rule of law in international trade rests on foundational promise. The states, regardless of power, will act within a framework of rules that are predictable, transparent, and enforceable. But this promise is increasingly at risk. What we are witnessing is not just a failure to comply with obligations. It is the erosion of the mechanisms that ensure legal accountability between states. This is not a theoretical crisis. It is a very real one, manifesting across multiple legal fora with broad consequences for economic certainty, geopolitical stability, and the legitimacy of international law itself. Let me briefly highlight three emblematic developments that illustrate that crisis. First, and all of you know about this, the paralysis of the WTO appellate body. The most visible symbol of the crisis is the near total collapse of the WTO's appellate body. Since 2019, the dispute settlement system of the WTO has been paralyzed, leaving disputes unresolved and enforcement in limbo. What's really at stake here is not just procedure. It's a delegalization of the trade system. Without binding and impartial adjudicative body, WTO law becomes fragmented, political, and increasingly susceptible to power-based negotiations rather than legal resolution. Some members have turned to alternative mechanisms like the multi-party interim appeal arbitration arrangement. While this initiative demonstrates adaptability, it also raises a fundamental question. Can voluntary plurilateral fixes truly substitute for a universal rules-based system? Or are we merely managing the symptoms of systemic collapse? Second, the United States Trump era and the deliberate undermining of international legal order. The Trump administration, which marked a turning point in the explicit abandonment of multilateralism and a strategic shift toward unilateralism, transactionalism, and political coercion. This episode illustrates a deeper trend, the displacement of law by raw political calculation. It shows how the legal rationale was increasingly treated as a post hoc justification, rather than binding constraint. And it reveals the world's most powerful economy was willing to treat the rule of law as optional, undermining legal predictability and reciprocity at the heart of the trade regime. In short, US tariffs was not just a breach of obligations, it was a deliberate challenge to the legitimacy of law as a constraint of state power. Third, the question of can rule of law trade survive in a fragmented global order? An increasingly urgent question is whether like-minded countries, those committed to the rule of law in trade and investment, can sustain or even strengthen a liberal international order, while some of the world's largest powers pursue mercantilist, autarkic, or coercive economic strategies. The challenge is structural. Rule-following states bind themselves through legal obligations, while powerful outliers use political and economic pressure, often backed by military force, to bypass legal constraints. In this context, defending legality requires more than commitment. It requires strategic adaptation. But there is an additional and deeper requirement: international consistency. Liberal democracies must apply the same standards domestically by protecting judicial independence, avoiding politicized trade remedies, and resisting populist protectionism if they want to credibly lead on legalism abroad. I conclude this by saying that we are facing the instrumentalization of law and legal uncertainty. The erosion of mutual trust in legal rules has a chilling effect not only on dispute resolution, but also on the negotiation of future agreements such as USMCA next year, or compliance incentives, and on the capacity of international law to act as a stabilizing force in times of crisis. Now, in order to set the stage for discussion, against this backdrop, today's panel will explore how state mechanisms, whether under WTO, USMCA, or broader treaty-based arbitration frameworks, can adapt and remain effective. Our questions will focus on this. Are we witnessing the repoliticization of trade law? Or is this the moment of institutional reinvention? Can interstate dispute mechanisms reassert the rule of law? Or are they themselves being co-opted by power asymmetries and normative ambiguity? Our distinguished panelists will address these questions from doctrinal, institutional, and legal perspectives, examining the practical tools available for restoring accountability and the deeper reasons of the crisis. As we listen to their insights, I invite you to consider this. Is the rule of law in trade still a meaningful constraint, or is it becoming an aspiration without enforcement? Now, I will change to the panelists, but first I will introduce my colleague, friend, and a great professional, Edna Ramírez Robles. Edna has 25 years of experience as international consultant in more than 58 jurisdictions worldwide. Her expertise stands on legal and policy issues on international trade and investment. She is the CEO and founder of GoBiz Global. She has worked with more than 20 national trade facilitation committees and has carried out technical assistance projects financed by many organizations such as USAID, European Union, WTO, and more. She worked at the secretariats of international organizations such as UNCTAD, Trade Facilitation, WTO, Legal Affairs, and IDB on Trade and Integration. Furthermore, she is the Dean of the Law Faculty and a professor of the University of Guadalajara, Campus Puerto Vallarta. She has lectured at American University and worked at Georgetown University with Professor John Jackson for the Journal of International Economic Law, and at the Graduate Institute of International Studies with Professor Jus Pauling. Edna Ramírez Robles graduated as a lawyer from University of Guadalajara, Mexico. Her PhD and LLM are from the Universidad Complutense de Madrid, Institute Ortega y Gasset, on European Studies, specialized on international trade law, and moreover, she has authored more than 60 publications. Edna, you have the floor. Thank you so much, and thank you so much you for listening.
Thanks to you, Carlos. It's great to see you again in this scene. And I would like to start by thanking, of course, Ricardo Ramírez and Hugo Romero for their invitation, and Samantha for being such a great host. And congratulations for organizing again this very critical event at this moment. So I would like to start by mentioning I have the honor of moderate this session, and I would like to start mentioning the biographies of truly experts in this field. Let's start with Ricardo Ramírez Hernández. Ricardo has more than 25 years of experience gained in more than 70 international disputes under different trade and investment agreements as a counsel, arbitrator, and member of the WTO body. Of the WTO appellate body, okay? I have to say that this, you all know it, but it was our first and only Mexican member of the appellate body. So in June 2009, Ricardo Ramírez was appointed as a member of the appellate body of the WTO. He served as he also served on the ICSID panel of arbitrators by the chairman of ICSID. Then administrative counsel of a team of 6 years, and he is the founder partner of RRH Consultores, who's hosting and organizing excellently this event. He holds the chair of international trade law at the Mexican National University, UNAM, where we are, and in Mexico City. From 2006 to 2009, Mr. Ramírez was head of the international trade practice for Latin America at Chambrun and Park, and where he focused his practice on full range of trade matters, including unfair trade practices, safeguards, trade facilitation and customs procedures, international standards and regulatory compliance, et cetera, et cetera. For more than 11 years, Mr. Ramírez provided advice on trade and competition policy matters related to all trade agreements signed by Mexico. Thank you very much. Then I will proceed with our next panelist, Mr. Edmund Sim. Thanks for coming to Mexico for this very interactive event and including this session. Mr. Edmund Sim is a internationally recognized practice, focuses on trade remedies, anti-dumping and countervailing measure duties, Section 301 of safeguards, customs, foreign investment, intellectual property, antitrust, and other issues. He has participated in over 260 trade remedy proceedings involving products from semiconductors to shrimps and in economies as diverse as China, Japan, Taiwan, Hong Kong, Malaysia, Singapore, Indonesia, India, Thailand, Philippines, Vietnam, Korea, etc., etc., etc. Mr. Sim represents exporters and governments in international trade disputes between Asia and Latin America, Canada, Africa, Europe, and United States. Mr. Sim has provided assistance to government ministries in China, Thailand, Malaysia, Mongolia, Oman, the Philippines, Cambodia, Saudi Arabia, etc. He also participated in studies for the TPP, for the EU-Asian FTA, and training the Continental FTA, and in investment laws and their consistency with the WTO agreements. Mr. Sim has taught in ASEAN Economic Community law at universities in Singapore, Indonesia, Thailand, and Timor-Leste. Together with Stefano Inama, Mr. Sim co-authored the foundation of the ASEAN Economic University Community and Rules of Origin in Asia, published by Cambridge University Press. And Mr. Sim has represented companies in dealing with the AEC and served as consultant to the Asian Secretariat. Last but certainly not least, Dr. Todd Whaler, thank you very much for making this possible, even that it was online after the event on the airport, but you are here and we're thrilled that you were able to make it. Todd Whaler is an independent arbitrator and barrister who specializes in foreign investment and trade disputes. As a pioneer in the field of investment treaty arbitration, Dr. Whaler has amassed over 25 years of experience serving as co-counsel, testifying expert, consulting expert, and arbitrator in many dozens of international disputes, which have involved an extensive array of clients, countries, economic sectors, and dispute settlement fora. Called to the Bar of Ontario in 1999, Dr. Whaler received an honors BA in political science, and to the extent that he also finished in the University of Ottawa and an LLM, an SJD in public international law from the University of Michigan. His name has also appeared in Who is Who legal list of leading international arbitration lawyers since 2007, and I believe the other panelists also have been in this very prestigious publication. Dr. Whaler joined Artibra International in 2021 as part of his transition into serving exclusively as arbitrator in international commercial and public international law cases, in addition to continuing his work as consulting expert for foreign investment protection measures. So this is the level of the panelists that we have. We'll have Carlos set the scene very well, and we will start now with, I would like to mention which is this interface that could exist between trade and investment. And the first question that I would like to pose the panelists, and perhaps Ricardo would like to start, because this is a trade matter as well that goes to his heart. We all agree that there is a rule of law crisis in international economic law. But is that crisis manifesting in the same way both for trade law and for investment law? Ricardo, you have the floor, and the other panelists can also comment on this. Thank you.
Edna, let me start by recognizing some people that have made this possible, starting with Hugo Romero, Carlos, Reyes, and Marijo, who went above and beyond in trying to make this event again happen. I think Carlos, when we started last time, when we did the first World Arbitration Update said that the important thing was to keep this up. And we're trying to keep this up, and we are doing the second one. We expect to do the third and fourth if we have partners and people that will support us. But again, I must start by giving a recognition to them and asking them for an applause for all their effort on this. So I was asked to start with the sad part, which is trade, and I think we have to be clear on how different trade law is from other types of public international law, and I think we need to start after World War II. Usually, when a country will win a war or a conflict, the immediate reaction will be to conquest the other ones and expand the territory. But when World War II ended, the winners, especially the United States, chose a different path and said, well, we're gonna craft a new international world order of law, and we will protect it. And that's why we started with the GATT, and then everything we started moving. And it was one of the United States, among other big countries, start being the guardians of the rule of law. And even we reached the pinnacle of this, and I'm talking only about trade law, in the WTO. The agreement that was able to reach countries, the WTO, were able to reach the WTO, was really something that needs to be recognized, because to be able to craft 500 pages of commitments in trade, services, and intellectual property, together with a robust international dispute settlement system, was quite an achievement. But everything will revolve again around international trade law. And so these were the glory days. We're talking about 1995 and on. I remember arriving at the appellate body in 2009, and everything was nice. Everything was good. And of course, I think it will be very unfair to tell that this crisis was created by one president entering into power. This is something that was brewed from a lot of time. This was not only a problem of one country, it was a problem of a lot of countries. This was also a problem of egoism by countries. And so at the end, why we are here today has to do with a lot of reasons, and not only one person or one USTR or one. I think it will be, we cannot point to anyone, at least for all the problems that were created. So fast forward, we are in Trump 01, and that's where the crisis started to become more real, and that's where the appointments of the appellate body start being vetoed. And at the end, we reach a point where you don't have a operating dispute settlement mechanism, or you have a crippled dispute settlement mechanism where it cannot work. And I think that in parallel, you have, and we've been talking a lot in the morning and mainly on all sessions, basically, about this national security. Because this was an exception that was included in the trade agreements that was used at some time, but at some point, but nobody will care about it for a long time. I will not even teach it in law school, because I never thought it was relevant to teach an exception on national security, but it became relevant. And I think this ties this has to do, and this ties to the crisis. So at the end, we in Trump 01, we reach a point where nobody, where we would not have an operating appellate body. But then when it became Biden won, and we all thought that this was just a nightmare, and we would be waking up, and everything was going to come back to where we started. But no, and I think there are a very good explanation, because at the end, just bear in mind that the WTO is a unique dispute settlement system in the sense that it's the only international adjudicatory system where the United States cannot refuse to adjudicate a dispute. And this has a lot to do, I think, with the crisis. So the first one that was going to fall was the WTO, and that had reasons for that. So there you go with Biden, and basically things stand in the same way. WTO Director General and WTO members kept making good promises that the crisis was going to end, that we were going to have a fully functioning. The last ministerial conference has a compromise that we will have a WTO, a functioning dispute settlement system by 2024. We are in 2025. I think I was trying to use Carlos' words on the WTO law becoming aspirational. I think I will use another analogy. WTO law could become environment law. Because environment law, everybody wants environment law. Everybody says that it's nice to have environment law, but nobody complies with environment law. So I think I will draw more an analogy going to environmental law than going to something that at the end we are there. We are facing a problem that some countries are basically disregarding the rules. It's important that trade is still moving. There are disputes coming to the WTO. And I think that at the end, there are some of us that think that there is still hope about the rule of law in the WTO. However, I think that we are facing a crossroad where we are not sure whether this will become the new reality. And I think we are here to debate what will be the new reality should this path be continued on basically disregarding the rules. Now, there are some WTO countries that have said, well, I will abide by them, I will keep abiding by them. The fact that not a lot of countries have taken retaliation against tariffs or doing something else is a good sign. The fact that, remember, a good percentage of MFN is still not affected by tariffs. So at the end, trade is moving. The problem is, as Carlos pointed out, is a problem of legitimacy of the system when the big ones start disregarding the rules. So I will leave it at that and maybe discuss investment on a later point.
Thank you very much, Ricardo. So can we find some similarities here, and which are the differences as well? Perhaps, Hernan, you want to take the floor?
Well, yeah, and again, I'd like to thank the organizers for inviting me here. Again, like the previous panel, you have a token American. I also spent 16 years in Singapore, so that colors my view on the current situation. And finally, before I go on a little spiel, it's like I also had Professor Jackson in Michigan, both for trade and for international law. And why I bring that up is because he taught those in two very different ways. Because the international law, as we all know, beyond economic regulation, is still is a very power-based approach. You know, no matter when you want to talk about human rights, sovereignty, all that, it's power-based. International economic law, because of a mutual agreement to follow contracts and to follow agreements, develop in a different way. And so the trade law course was taught differently. But even at the heart of it, Professor Jackson recognized that this power thing could rear its ugly head. So, for example, in the final examination for trade, he gave like a 10-page, single-space fact pattern, and you had to find as many trade violations or how many other ways you could sue somebody under U.S. trade law. And in there, because of something he had said, I wrote that the U.S. president could invoke the IEEPA to impose a tariff on everything from countries claiming a national security emergency. This is in 1989 when I wrote that, and I got an A+ for it. Yeah, I got A+. And the reason he said that is because he heard that from his predecessor, who was Bob Lighthizer. So this has been the idea of doing Liberation Day has been around for 30 to 40 years. Okay, so that sets up a coloring of how I view these things. I think the issue is going to be, we like Ricardo said, we've been headed this way for a long time. It was not just the United States. Other countries were trying to revert the international economic legal system to a power-based system again. And however many ways you want to slice it, there's a lot of blame to go around. The real victims in all this are the smaller and medium-sized countries like Mexico, like Canada, like Singapore, et cetera. They were hoping that, and aspiring, that the international legal restrictions and limitations would bind the big powers into supportive behavior, constructive behavior. This is fading away. So, and it's something where it's going back to the norm. So the way to use a pejorative, a very prosaic example, where are we headed? We are headed in this, are we going to head into a system where, again, American here, we have football and we have football, okay? Are we headed to a system where only Americans play football with wearing big helmets and a round ball a ball that's not round, and we throw the ball, but only Americans care about it and some people in Mexico City, and maybe some Canadians who follow the Canadian version. And then everyone else follows.
Which is better.
Yeah. The normal ball, which is round, you kick it with a foot, okay? And in that regard, everyone's happy. It's like, you get to have your thing, NFL, you get to have Tom Brady and all these folks, and you get Messi and all these people every 4 years, and we Americans don't care unless somehow America gets past the first round. So, or if it's women's sports, okay? If it's women's sports, then we care because we know soccer is a women's sport in America. Or are we going to be like the Olympics? And why I bring up the Olympics is some years the Americans do well, some years they don't. But they still follow international rules, and they follow in specific sports. Ice skating, track and field, basketball, right? The Americans, if the Americans' view of the world is that if every sport was like basketball, that would be great because we win every time. But on the flip side, the view of the Olympics is we accept the system because it's good for us. Why do we accept that? That's why we pay all that money to watch the basketball when it comes in from Paris or from LA next time. That's why, because money and self-interest is involved. So if the real future of the system is if we can encourage countries, and not just the United States, but China and other big powers like India, to understand that there is value in having a rule-based system. Maybe not an extreme rules-based system where individuals can invoke investor-state dispute resolution or escalate and have private rights. We're not headed there anymore. But in understanding that this is good for us, then maybe the pendulum will swing back. Because one of the things about President Trump is that of all things, yes, he is transactional. That's a good and a bad thing. But if he sees that the value of the transaction, the value of a long-term commitment in order to support U.S. norms and aspirations is consistent to some extent, not always, with the international norms, then I think we can head back. But right now, we're in a transition, and it is going to be very bumpy, and just like, again, the difference between football and football, right? So that's literally what we are right now. The Americans basically said, we are going to play football, and if you don't want to get up to 300 pounds and get a bunch of helmets and you know, play it our way on the gridiron, then fine, we don't need you. That's the approach right now. But at some point they'll realize, oh, hey, maybe like we are actually good at football and with women's sports, let's win that too. That's just a pejorative way of putting it forward, my view of the situation.
Thank you very much, Edmund. Very interesting, all these scenarios. Positive, I should say, for what we're living now, but it gives us hope. Todd, I would like to follow up the same question, but if you can highlight how this national security exception works in the investment treaties, and what is your view on what is the crisis of the rule of law that exists in the investment arena? Thank you.
Thanks. I have to begin by noting that Andrew Naismith, the man who invented basketball, was also Canadian. And that the Canadian game is much better because it's bigger end zone and only 3 downs, so a much more enjoyable game. Just saying. But Canadians have a habit of having to do that. We have an inferiority complex with respect to the US, so we have to always assert the things that we develop that they now like. So with respect to the rule of law, I think that I should mention first, when we heard about the tracing to the late 1940s, post World War II, the trade regime, well, there was also an investment regime that was stillborn, whereas the GATT was supposed to be like an early harvest and therefore came into force. The ITO didn't. It was supposed to be the WTO 50 years sooner. And in the ITO, there were investment provisions. They were just so twisted by politics at the time that the US itself decided that it would not accept the ITO as a going forward proposition. And that's why instead we saw bilateral investment treaties. Originally, we saw agreements that didn't have the characteristics of a bilateral investment treaty, but they did have the characteristics of an establishment treaty, which would promise MFN and national treatment without the ability of binding and dispute settlement. That didn't happen until the very late 1960s, early 70s. But nonetheless, so it's funny because in a way they started together, trade and investment. They diverged for quite some time. The trade side was able to finally get itself together and have a multilateral agreement in the late 90s. And again, at a very similar time, the same work was being done at the OECD to create a multilateral instrument for investment. It just didn't happen. So it's ironic in a sense that that investment law ended up having a more durable enforcement mechanism over time than trade did, given that the history of investment protection, going back even before World War II, is a series of failed attempts to multilateralize the system. So just a little history there. So when we talk about state-to-state mechanisms, if you look at the US model bit, you'll see that what's interesting about it is it takes some elements of the investor-state dispute settlement model, which of course is just another section of the same treaty, or draft, in this case, draft treaty, model treaty, in that it's not like most trade agreements where ultimately if a fundamental challenge is made to the system by, let's say, a refusal to a point, that ultimately mechanisms generally can't move forward. The WTO is just a really terrible example in that rather than worrying about refusing to appoint individual circumstances, they just refused to appoint the appellate body to the point that it was inutile. But anyway, in the U.S. model bit, this model is very similar to thousands of other treaties. It actually requires it requires the parties, if they have a dispute about interpretation of the treaty, that if they can't agree, then a set of rules, the unsubstantial arbitration rules, will be chosen for them. And if they can't agree on a tribunal, the Secretary General of ICSID will appoint one for them. So it's interesting because that means you are going to get a result in a state-to-state mechanism still today in the investment treaty angle. But of course, as I just noted, you've got a whole bunch of different treaties. So just because I mentioned this one doesn't mean that, let's say, the USMCA, for example, has a different model or at least different twists to it. But still, it's interesting that we do have, while they follow different paths, in some ways they have different characteristics today than we might have thought that these two brothers, trade and investment, would have had. I like to think of the rule of law challenge in investment to actually have started in the late 1990s. That's when you first saw claims being brought reciprocally against countries like Canada and the United States, which seemed for some reason to shock the parties, even though they were bilateral and multilateral agreements. So of course they could, you could find a problem with all parties to a treaty. But the backlash actually started then, and then it increased after the Fukushima nuclear disaster when the German government, seemingly at a fit of pique, decided to cancel all nuclear power plants in various stages of development, and then found out that their treaties would at least make that harder to do without compensation. So I think that that's how early the rule of law challenge comes, and it doesn't come in starving the system of dispute settlement arbitrators or panelists. Rather, it starts with the tinkering with the agreements themselves. So a lot of the agreements had mechanisms in them that allowed the parties to a treaty to agree on a binding interpretation that would actually limit the provisions as they arguably stood in writing. And then also you had renegotiation and redrafting of the treaties. So, and then you have, today we see that's been taken up in an unsubstantial body. So all these various attempts at limiting and winnowing and narrowing the protections as they originally stood. That's one side of it. The other side of it are the binding, so I shouldn't say the one side. There's two sides. One side is binding arbitrations issued after the fact to basically correct so-called wayward tribunals, and then limiting and redrafting of the treaties. That's 1, 2. The other box is national security. So with national security, I think in a way we saw, especially let's say with the Argentinian and the Spanish cases, we saw something that in trade law kind of never really happened. In trade law, national security was always the big nuclear threat that nobody wanted to have happen. And so states would do anything to avoid submitting something to dispute settlement at the WTO panel level and then the appellate body level if it really was going to be fundamentally about national security. In the investment context, they crossed that barrier and they started using it. What's interesting, though, is that I think while the consensus generally in the trade context is that a national security exemption probably can't really be second-guessed or look behind. In the investment context, largely it had been looked behind. And so the good faith of the parties was questioned. All that being said, national security, obviously, it has its its counterpart in exactly what Edward was talking about with respect to arguably a bad faith interpretation of the national security laws of the US to impose tariffs. It's basically the same thing. The question is, are we willing to obliterate the basic good faith understanding of what national security was supposed to mean to simply let it really be a naked assertion of power so that you can't find me guilty of anything. Sorry if that was too long and rambling, but I try to tie a lot of pieces together.
No, very clear. Thank you very much. I think Ricardo has a two-finger thought here.
No, just reacting briefly and just to the national security. You're right, Todd, but we haven't had an investment case where the national security exception is treated like the main exception or defense head on. And should there be any case against the United States regarding the tariffs, I think that is one case where we will see exactly this discussion or whether there will be the main discussion. Now, to me, the problem, and we were discussing in the morning, and I kept thinking about what was discussed by Lauren, that it is right that there are a lot of national security clauses all over the place. And there are some BITs who even don't have a national security clause. So, and I go to fragmentation and to Vienna Convention. And that is a problem that is not happening in trade, even though I know USMCA has a certain different national security exception than NAFTA, but at the end, the main thrust of all those exceptions are the same. Whereas in investment, you have very different national security. And if arbitrators are loyal to the Vienna Convention, there could be different interpretation on national security, on the scope, on how you can invoke them. So I think this how you deal with national security in an investment context may come to a different results, let's say.
If I may just add there to make it more complicated, especially we saw in the Argentinian cases, it was also possible to bring the public international law exception with respect to national security in a broader sense. So you saw that in the Argentinian cases where it was basically, if you don't like my use of the actual provision, well, we can talk about it in public international law too, which makes it even more diverse and diffracted.
Wonderful. So this national security is still the elephant of the room, and there is a clear a trend, or that it might be invoked soon, and in this investment law area. It seems that for the trade arena is our everyday now. So I remember when I worked at the WTO, when the first case arrived with national security, with the defense of the U.S. of national security, everyone was in crisis. So this is where the crisis started as well. Shall we go to the next question? So whereas international trade law dispute settlement remains a state-to-state activity, investment protection treaties typically provide for both state-to-state and investor-state dispute settlement. Does the current international political environment render this fact a distinction without a difference? Or let's put it this way, how does the state-to-state dispute settlement crisis might infect ISDS? Shall we start now with Todd?
I kind of covered some of this already. So, I mean, basically, I think we come down, if we think of it, if I put on a political science hat with the historian hat, with the lawyer hat, and try to wear three hats at the same time, it's really about fundamental questions and people's willingness to ask them. So if we're really willing to ask whether a system can work or whether it should work, and we do see in the Trump administration myriad examples, both as a matter of domestic law and as a matter of international law, pushing that far, testing that far. If we really do say, well, what if I do that? Rather than thinking, well, no, that's a fundamental norm, we can't do that. If we fundamentally question or challenge a system, then a lot of things are possible, not necessarily in a good way. I think Edward would probably come in and will come in on this with respect to a theory of a power-based model, which therefore would not be a legalistic, classically liberal model, which is certainly how the investment treaties were based. So to try to concretize that, so let's say a state has a case against it, and that it's found that it's liable and therefore must pay compensation to an investor. Well, what happens? Well, there's two things that can happen if we're talking about fundamental challenges. The one is the state refuses to pay. Now, that happens a lot nowadays. It happens more and more, I think, as part of the overall challenge to the rule of law. And what normally would happen is then the claimant would have to hire some new lawyers and some new investigators to try to be able to catch some assets that are not being used for the purpose of a diplomatic representation, and then seize those assets and try to liquidate them. That's possible with certain states, but is it possible with the behemoth like the People's Republic of China or United States, the two biggest economies? Query, is that possible? And of course, the other thing that a state in that position can do is it can also renounce the treaty and therefore prevent any future cases being brought that it might have to face. And we see examples of treaty renunciation, of course, in the Americas. So there are certainly ways to react to that kind of challenge. The state-to-state mechanism, in a sense, is a weak sister or a poor example, in that it's really just like a better version of most just state-to-state dispute settlement in your typical trade treaty, because all it means is you're going to get a tribunal and it's going to give you a result. But that's just when the negotiation starts, if there's going to be one. And then again, we're in a power arrangement, rather, perhaps even a patron-client relation, rather than a legal situation. And in that regard, I could give some comfort, I think, in the sense that, again, if we're talking about fundamental questions, arguably that's always the case. Two parties go to a commercial arbitration, they come to, they make all their arguments, an award is issued. Well, the question then is, are you going to try to enforce it, or are we going to try to make a deal? Ultimately, people have to come to some understanding, and in that sense, all the award or even the judgment is a starting point for the next step of negotiations. So it can be a house of cards, or maybe, practically speaking, it's just a way that the system can work.
So just a quick follow-up to what Todd is saying. The real value of the dispute resolution process is not that it is used. Okay? Again, in the Asian context, for example, like comparing it with USMCA and NAFTA, like USMCA and NAFTA, many arbitration panels. In Southeast Asia, do you know how many arbitration panels we've had under the existing dispute resolution treaty? Nada, zero, bumpkus, okay? But people still recognize the rules and they agree to live by those rules because of the threat that it could be used. So the reality of dispute resolution, you know, and its effectiveness in arbitration in both forms that we've talked about here, is the effectiveness gives credibility to the system. When the system begins to break down for dispute resolution, then people believe in it less. So for example, if I believe that, you know, I let my dog poop in your front yard and nothing will happen to me, then next day I bring the dog again and again and again, well then my neighbor has a yard full of dog poop, right? That's good for nobody except maybe the dog. So that's the value of the system. And my concern, before I turn it over, is like, my concern is not just with that, but if you have underminings of the investor state and state to state, what about private arbitration? What about people who have an arbitration clause in an investment agreement, and then the court starts saying, well, I didn't agree to enforce that, why should I agree to enforce this? Then we are really in, going back to the dog analogy, a dog-eat-dog world.
Or the dog poop hits the fan.
What if investor state has gained life on its own, so important that they will never be infected? what if at the end, and I agree with Todd that the quick thing, the key thing is enforcement. That's the key part. So, and we have had cases where countries are starting to say big, not that small, saying I will not pay. So what is going to happen when countries start saying I will not pay? And what if a big country, a very big country, you get a case that you lose and you are asked to pay X millions and the country says, I will not pay. And there are precedents where countries have said, refuse to that. So at the end, I think there could be one scenario where investor state will never be infected and will have a life on its own, and it will never be a crisis, and we will never be worried about the neighbor. But the second scenario, and I think if the crisis is going to come from one place, will be in enforcement. Will be in enforcement tied with exceptions. And I am sure that if the United States were to be involved, if at all ever, in an investor-state disputes where a national security exception is invoked, and the tribunal comes to a different conclusion, and that the U.S. wants, I think we will be starting a discussion, and I think Ed would like this. I will draw an analogy of zeroing. So at the end, this has to do with something that the United States really opposes and really believes on, and will say, no, I will not accept that. And then we will have the United States engage, maybe in a multilateral agreement, maybe in a multilateral scenario, trying to come up with things that will secure that interpretation. So I think that if, coming back to the question, if there's something that will have it's something where the problems could come up from, I think, are enforcement and exceptions.
I think we should just note on that last point that there is a case called the Lowen versus USA case, where an arbitrator, a couple of years afterwards, the US arbitrator actually basically admitted in a small group setting in Ottawa, at the University of Ottawa, that he had been separately contacted by the US Department of Justice, and it was impressed upon him how important it was that the government not lose, and that he carry that information to the other two arbitrators, which and that's what he had said there. And then what conclusion one can certainly draw from that is that we've already seen this. It's already happened. The question is it going to just be a little bit more, a little bit less discreet?
So thanks for identifying this. I mean, we have a clear parallel of what are the procedural issues that have affected the trade arena, but also some other issues related directly to decisions or interpretations of the former appellate body that didn't like, right, the U.S. So we, the biggest point of Ricardo is like, this might start when the U.S. loses, right? So, or this is the biggest threat that we have in front of us, which in investment, there are areas for this to happen in the enforcement and with the use of exceptions. So let's go to the third question. That is it practical for like-minded countries to maintain or even strengthen a classically liberal approach to transnational trade and investment founded on the rule of law principles, while some of the world's largest economies pursue an alternate agenda? We know it, reverting to an autarkic and mercantilistic approach, backed by political, economic, and even military power. Is this just a temporary impasse? impasse. So, Edmund?
So I think there is hope, and you can look at the now 6 weeks after Liberation Day, right? Because on April 2nd, everyone said the world was going to collapse. And I guess stock markets did collapse, but they recovered now in the US. But more importantly, if you look at what happened, there was retaliation by some countries. Most countries didn't do anything, that they tried to talk. But no one, except the Chinese, went through the national security exception. Nobody retaliated immediately. The EU treated the US tariffs as a safeguard. Other countries treated it as a safeguard and just said, well, we're going to apply the rules. So there is hope there. There is also hope, even if this goes to the WTO dispute process and it goes and then it's appealed into the ether. There's still value in that. Look at another comparison, like the Philippines versus China on the sea dispute in the South China Sea. Yeah, that process went through and China doesn't recognize it, but it's still there. There is value to having that as part of the process. It's for a political and a diplomatic level. The final thing I would say is not every country wants, I think you're seeing over the last few weeks, countries do not appreciate having trade stuck into everything. So, for example, last week we had the Pakistan-India skirmish, shooting out fighters, bombing, etc. And the U.S. got involved, resolved, negotiated ceasefire. But, the U.S. government said, oh, yeah, and we settled all this, and we told both parties that if you continue to do this, we'll impose trade restrictions and you will have less access to the market. Of course, and the Indians hit the roof. So there is value in compartmentalizing economic relations and trade and investment from the rest of the world of international law. That's why that's why it was set up that way after World War II, as Ricardo talked about. So I think there is, if these sentiments, these strings of sentiment continue to hold true, and most importantly, so long as China and India to some extent at least follow the outlines of international investment and trade law, even though we all know they don't follow it all the way, that will give the other major party time to help keep this together. And that other major party is the EU. And unfortunately, the EU being what it is, takes time for it to do anything. So my comment is that I think it's there, but it will take time. And I think, and it's going to have to be a long, drawn-out effort, because don't think that this will end just because the end of the Trump administration, 3.5 years from now. We could, for example, have as a counter reaction the election of a Bernie Sanders AOC government, right? That type of government. And those guys don't like, is this, an arbitration either. So the problems we're talking about transcend one person, one party. They transcend, to some extent, the entire one government. They transcend all governments. But I do think that, there is some silver lining in all of the dark clouds that came out after Liberation Day.
I would agree that there is some silver lining. The problem is that enough of it? Because what we're seeing is, at the end, this is totally right, the reaction by countries to the unilateral, to Liberation Day was quite thoughtful, let's put it in that way. And of course, there were countries that will be more affected to retaliate than not. So there's also a trade component to that. But overall, countries like still abided or tried to abide by the rules. China, the EU, all tried to work cases on that. But my problem is that we keep discussing tariffs when we should be discussing other things. And we should be getting agreements where we are not getting. We have a fishery subsidies agreement, which has an explosive clause that says that it's going to blow up if no agreement is reached. We have a digital trade agreement that says that if we don't reach an agreement by X, it's going to explode. So at the end, trade keeps moving on. Environment will be something that we need to sit down and discuss. So at the end, okay, we're fine. We're not going to retaliate, but we keep discussing tariffs. And I don't think, my problem is that I don't see any scenario when 160 members reach agreements, substantial agreements on the substance, to keep forgetting about tariffs and try to address issues that really everybody cares about. That's my problem.
Todd?
Just so one point doesn't affect Edward's analysis at all, but Canada did retaliate immediately as well. So it wasn't just China. In a way that was perhaps somewhat either more crazy or valiant, because Canada can't win a tariff fight with the United States. But I think it was essential that happened. And again, doesn't change Edward's analysis at all. Also, if I'm not mistaken, the bond markets haven't really recovered for the US, even though maybe the stock markets have. And that, of course, goes to fundamentally whether or not the bondholders still think of the US as the most safest harbor. Funny, another point that came to me from what Edward was mentioning, compartmentalization. Arguably, that was one of the biggest selling points of investor-state arbitration, because it was meant to take any hot-button investment issue or expropriation issue off the diplomatic table, so that the diplomats could talk about more important things with each other and not have to spend time representing an important investor of one party or whoever that might be on the other side. Final point, actually final 2 points. First point, I think the answer to the question is yes, that it is possible for states, certain states outside of, let's say, the biggest 2 or 3, to maintain a classically liberal rule of law based system. And the best example of that are the thousands of bilateral investment treaties and multilateral, like 3-way, 4-way investment treaties, which can still exist and can still have impact. So I think that's good news that they're there, as long as they don't get negotiated down into meaninglessness. And then the final point is, I don't know if I mentioned it, but I actually I'm all but dissertation in a second PhD, one in history. I won't go into the reasons as to why I'm not finished it, but my dissertation, one of my theories that informs my research in this area is that you could apply sort of like a sine wave, or maybe an uneven sine wave. But you can apply wave theory to the way the world has regarded, what's the word? The German word for, it's not coming to me right now. The word for the culture of the time, the dominant culture of the time.
Zeitgeist.
Say it again?
Zeitgeist.
Thank you very much. Yeah, confession, I have ADHD, and one of the things with ADHD is you cannot pull a word you know very well out when you really need it. So it's better when it's this rather than on my wife's name. It's much better to forget this instead. If you look at, especially if you look at the investment, you can actually see a wave going through probably from early 20th, maybe even late 19th century, all the way to the present, where we see it's either classical liberalism, freedom, rule of law, or statism in all of its forms. So that can be, basically it can be any form. It can be communism, it could be despotism, it could be authoritarianism, but statism in any form. And it appears to me, if I were to try to chart it, that basically it was around the turn of the century, this century, when we started seeing the pendulum starting to swing back to the statist side. And the only problem is I don't think we have any indication of when the pendulum is going to reach its final point before it starts swinging back. Be that as it may, that seems to be something that you can trace through the history of international economic law over the past 150 years.
Thank you very much, Todd. Now we're at the end of the session, but before we conclude it, we would like to hear the audience if there is any question.
Well, I think the question now is, if you compare or you talk about, at the beginning, Ricardo, you were explaining that what is the current state of the art, if there is a rule of law crisis in trade terms, and what is currently happening with this vetoing of appellate judges in the dispute settlement mechanism of the WTO. I think I'm curious on what are some of the efforts that, in order to solve this crisis, considering that there are different actors within the WTO and perhaps there is certain interest of the US of not having that resolved. I think Hugo was describing at the beginning that if it's a good or a bad thing of not having an appellate mechanism and still having trade disputes ventilated through the special groups. So, and I'm doing that comparison with an investment arbitration where perhaps within the, even if it's sufficient or not, within the UNCTAD Working Group 3, they're doing certain efforts to change the system to make it more better. So what are some of the alternatives that have been done within the WTO or these special groups, or of having a new appellate mechanism where perhaps the US is not a participant in it? Just curious of how they're going to be this issue resolved, if it will be or not.
Jorge, I think the problem in the WTO, it's not only one country. It's, first of all, a lack of willingness by the membership. And I think this has to do with the membership being worried about some other things and not only try to solve the dispute. And I think I'm being quoted, right? Well, I don't care. There's also been a little of lack of leadership on the side of the Director General of the WTO. At the end, I think there will have to be some push for members to try to reach an agreement. It seems that dispute settlement is no longer important and is being bundled with the rest of the issues. So I think it's going to be very complicated to reach agreement because now the WTO dispute settlement problem is mixed with other problems. So you will have to reach a full agreement in order to solve this. And I think, although many people will disagree with what I'm about to say, that in any scenario, I don't see an appellate body again, ever.
If there's no more questions, or at least when the very last question is done, we need Hugo to make us all feel good and give us something nice to leave the building with. So he needs to come up with something nice to say. So he's got to think about that right now.
So it seems that there are no more questions. So
you're up, Hugo.
and we end up with yes, with
He
not
left the building, so.
As we are concluding this question, and but before we finish, we would like to acknowledge and to thank again the organizers for this impeccable day, for keeping up with this session, and for being able to handle this magnificent panelists. Thank you very much, Ricardo again, Hugo again, for this, and thank you all the panelists for this insightful contributions. And also, thank you very much for the participation throughout the whole day of the audience. And thank you everyone who joined today also online. And we hope this dialogue continues beyond this session and contributes to building a more stable international legal order. Thank you very much.
Now, taking stop advice, shouldn't we have a last word from Hugo and Maria Jose? No? No.
Well, if he's got one.
No?
Otherwise, it's time to feed the dogs.
Okay. Okay.
Bye-bye.
Muchas gracias a todos. Gracias a todos.
Muchas gracias.
Record.